My name is Kumar Prateek. I am an advocate having more than 5 years of experience, post-qualification experience, and I have handled corporate commercial disputes in all of my experiences. I've worked in Delhi and I've working in Patna and Delhi, both the jurisdictions. I handle cases uh, of both jurisdictions, and I also handle cases of outside jurisdiction, but with the help of the local councils there, right? And I've I've gained experience in recovery matters, especially in insolvency and bankruptcy disputes and MSME disputes, arbitration, and general criminal litigation as well. So I do practice primarily before Delhi High Court, Patna High Court, and National Company Law Tribunals, arbitral tribunals, and district courts as well, right? In civil cases and intellectual property rights disputes cases. So this is my brief introduction. I've graduated from Damodram Sanjeevya National Law University, which is in Visakhapatnam, and since then I've been working and mostly doing cases of recovery litigation, right? So delayed payment recovery cases, be it for MSMEs, be it for other corporates, be it for other corporates in insolvency and bankruptcy disputes. So all of these things that I've done, and I've given an opportunity by UDYAMITA Helpline. And I'm grateful for that, to speak and to disseminate all the knowledge that I can to all the MSME owners or MSME entity holders, right? So we'll start the webinar for today, if you all are comfortable. And thank you for joining the webinar today. I hope to add some value by the end of this webinar. So what I'm sharing my screen now, yeah. So we'll be talking about the issues of delayed payments to MSMEs, the challenges and solutions for rectifying these challenges, right? So what we'll all be discussing for today's what we'll all be discussing in today's webinar is the definition of MSMEs under Micro, Small and Medium Enterprises Development Act 2006, the qualifying conditions to apply for registration under MSMED Act. So what are the definition of MSME? What are micro, small and medium enterprises means? What does enterprises mean? So all of these will discuss. And second is the qualifying conditions to apply for registrations under MSMED Act. So if there is an enterprise, what are the qualifying conditions for it to apply in each of these categories, right? Whether be it a small category or the micro category or the medium category. So what are the qualifying conditions for an enterprise to apply in each of these categories? We'll briefly discuss those, and challenges and issues pertaining to delayed default stuck payments from buyers. So what are the challenges? What are the issues that if not taken care of well enough, generally ensures or gives the leeway for such issues to arise in the first place, right? So we'll discuss that challenges which the general MSME enterprises face in the issues relating to the in the issues relating to delayed payment, right? The important provisions under the MSMED Act for the benefit of MSMEs. So the MSMED Act is a central legislation, right, which is drawn out for the benefit of MSME and to facilitate the functioning of MSMEs, right? So we'll discuss those. What are the provisions under these act? So what are the provisions under this act which can be used for the benefit of the MSMEs, right? Or uh, the important provisions under benefit of MSMEs, which are not generally for the recovery of delayed payment. There are other provisions as well, right? So there are other provisions which are generally incorporated for the benefit of MSMEs. There is preference in procurement policy, right? So even if an MSME is not an L1 bidder, and there is a percentage in the procurement preference policy by the government, so even if they are not the L1 bidders, they get the lowest. They are treated as L1 bidders just by the virtue of them being MSME, right? So these are the small benefits that the central legislation provides. The central legislation also provides subsidized loan rates, right? Interest rates for taking loan and to facilitate businesses also. And then we'll talk about the solution and way forward to resolve the issues of delayed payment. Once the issues have arisen, once the issues of delayed payment has already happened with you or already have occurred with you, then what are the solutions and what are the way forward that you can opt for to effectively deal out your way, deal out of the ways of delayed payment, right? And to realize your delayed payments, stuck payments from the vendors. So we'll discuss those also. Preventive measures to avoid delayed payment that can be adopted internally, right? So there are a lot of preventive measures also that you can adopt, which ensures that these circumstances, these occurrences do not happen, right? And if they do happen, you have a already you have already a mechanism in place through which you can easily prove the dispute, right? And you can easily prove that this was the default amount which is stuck with the other party. So these are some modalities that you can adopt internally in your business, which would go a long way in helping you to effectively wrestle your way out of the delayed payment cases, right? Because a lot of documents has to be recorded, right? A transaction has to be recorded. How the transaction transpired has to be recorded, and all the communication between the parties which happened during those transactions has to be recorded, and all of these records forms the part of evidence, and these evidences are the records on which a independent party would rely upon and would decide that whether you have a claim or not, or whether you have defaulted or stuck payment against the other party or not. So these are the preventive measures, a lot of preventive measures that can be adopted internally in a business, so as to ensure that these occurrences do not happen in the first place, right? So we'll discuss those also. The resolution mechanism. Once these issues have already arisen or already have occurred with you, so what are the resolution mechanism? Alternate dispute resolutions, we'll talk about. The online dispute resolutions, the same thing, which is done on an online basis. So we'll talk about both the ways, and then we'll talk about litigation, which is the age-old principle of recovering money. So you go to court and you litigate. You put your pleadings, the other party put their pleadings. They both argue on the point of law, on the point of facts, whether they have a claim or not, and the court decides whether you have a claim or not, and if you do have a claim, what is that claim, and how that claim is to be recovered, right? All of these things generally are taken into account in the litigation blanket, right? So whenever you go to court, whenever you plead before a court or a tribunal, then all of those things are considered as litigation. So we'll talk about litigation. And the last thing is things to keep in mind while doing business for its effective management. Tips and suggestions. Some tips and suggestions that we have collated in our experience, and which are very much insignificant when looked at it, but then it has a huge impact when it has a huge impact and significance if these tips and suggestions are incorporated. It is not realized in the long run, but someday you'll realize that these were the tips and suggestions, these were the incorporations that you made, which has saved you from a lot of time and a lot of resources as well. So we'll talk about that also. So I'm moving to the next slide. And also, I almost forgot to wish you all a very happy new year. So I apologize for that. And from the bottom of my heart, I wish each one of you a very happy new year. I wish that you prosper in your business and you do not have any of such issues to face in the near future. And if you do, well, I'm here to help you out. So let's move ahead with the webinar. So what are the conditions precedent to be registered as MSME under the MSMED Act, which the last amended notification was 26/6/2020. Through this amendment, the MSME department has categorized the enterprises, right? So before this amendment, there were two kind of enterprises which were registered under MSME, right? Those were manufacturers or service providers. Now, after this amendment, they have included traders of good as well in the enterprises definition. So what are enterprises? If we talk about the definition of enterprise, the enterprise definition is open-ended and widely and has a very wide ramifications, right? So any enterprise, any entity which is situated anywhere in the supply chain. So if it's a wholesaler or if it's a trader or if it's a service provider or is a manufacturer of the goods. So all of them can get themselves an MSME registration. The only exception is that the traders of the goods are included in the definition, but they are not given the other benefits of MSMED Act, right? So they have only restricted benefits available to them. They cannot go and they cannot use to they cannot use for themselves the dispute resolution mechanism which is provided under the MSMED Act. So how do you, if you have a delayed payment case, then MSMED, you cannot recover your case by filing your application in MSMED Act. You'll have to go to the other ways of recovery, which might be arbitration, which might be litigation, and which might be, if depends on the case, can also be insolvency and bankruptcy, right? So for traders of the good, the benefits are not available, but for manufacturers and service providers, so if you're into providing services to other party, or if you're manufacturing some goods, then you're considered as a, well, traders are also considered as MSMEs. You are also considered as MSME manufacturers and service providers. The only difference is that you are given all the benefits of the MSMED Act, being a manufacturer or service provider, which is not true for the service, which is not true for the traders of the good, right? Because traders of the goods are given restrictive sectoral benefits, which might be restricted only to having subsidized rate of loan rates and all of those things. They cannot come and they cannot use for themselves the dispute resolution mechanism available in MSMEs or the other beneficial provisions available in MSMEs, right? So, what are the parameters according to which you can see on in what classification you fall into, right? Whether you are a micro or a medium or a small enterprise. So the parameters basis is on which the classification is made between MSME are investment made in the enterprises, which is plants, machinery, and equipment, and also the turnover immediate preceding financial year generated by the MSMEs. So I hope I'm clear that if the two parameters are there, there are two parameters on which the classification is made. So the first classification is that what are the investment that you have made in the enterprise. So the investment, when I talk of investment making in an enterprise, you can talk about the expenses that you bear in plants, machinery, and equipments of 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 the enterprise, right? And also the turnover in the immediate financial year has to be taken into account to determine whether you fall into a micro category, small category, or a medium category, right? So the parameters lay out the quantum of investment and turnover required for the registration as MSME under MSMED Act. So there is a quantum already fixed by the government, right? So if you fall in that quantum, then I guess I'm so sorry. This is ad. So if you fall in that quantum, then you can go and you can get yourself a registration in that particular category. And if you do not fall into a particular category, then you can try for the next category to get yourself registered in the next category, right? So we'll see the table that we have formed. So the table laying out the quantum of investment and turnover for enterprises to be registered as any of the micro, small, or medium enterprises under MSMED Act, right? So there is a note, both the parameters, investment and turnover, has to be met for an enterprise to qualify as either micro, small, or medium enterprises basis the parameters laid out here in below, right? Investment includes in its expression all tangible assets except land, building, furniture, and fittings. However, the turnover shall be computed based on the preceding year's ITR filing, right? So all of these are clear enough, I guess, and needs no substantiation. So if we talk about investment, it includes in its expression all tangible assets, right? Like plants, machinery, and equipments. They do not include in itself all the intangible assets, like the expenses of the land, of the building that you have constructed, right? So all of those cannot be taken into account while calculating your investment in the enterprise. However, your turnover has to be calculated in your preceding year's ITR filing. So I hope that's clear. For the micro enterprises, the investment made in the enterprises should be either 1 crore or less than 1 crore. So if it is less than 1 crore or either 1 crore of rupees, and the turnover generated annually is less than anywhere less than 5 crore rupees or 5 crore rupees, then you're eligible for get yourself for your enterprise to get a micro registration, right? The same is for small enterprises. If your investment made in the plants and machinery exceeds 1 crore, or goes to 10 crore of rupees, right? Or anywhere less than 1 crore to 10 crore bracket, in anywhere between the 1 crore to 10 crore bracket, and the turnover generated annually falls in the 5 crores to 50 crores bracket, then the registration available for your enterprise would be small enterprises, right? And the last one is the medium enterprises. So the investment made in the enterprises has to be between anywhere between 10 crores to 100 crores, and the turnover generated annually should range anywhere between 50 crores to 250 crores. Now, there is one interesting thing to note here is that for the medium enterprises, which are generally large enterprises, because they have investment made in the enterprises ranges between anywhere between 10 crore to 100 crores, and the turnover ranges between 50 crores to 250 crores. So for those enterprises which are registered under the medium category, they cannot come, and they also cannot use for their benefit the dispute resolution mechanism which is there in the MSMED Act, because the MSMED Act talks about constitution of a micro small enterprises facilitation council, which is called MSCFC. It is there in every districts and state, and sometimes for a group of districts there is one MSCFC, and it is generally present. They have an abundant presence in all over India to adjudicate upon the cases of the MSME. So only micro and small enterprises can come and can resolve their dispute under the MSMED Act for delayed payment cases, right? So this has to be kept in mind, that medium enterprises cannot come and cannot file a application under the MSMED Act for the resolution of their disputes relating to delayed payment or relating to anything, right? So this has to be kept in mind. I guess we are clear till now, and there are no confusions of any sort. Okay, so we'll move to the next slide. Now, we'll talk about the reasons for the delayed payment and its consequential effects on MSMEs, right? Because MSMEs, by the virtue of being micro, small, and medium enterprises, as the name suggests, are not very large corporate houses, right? That they can keep on running, keep on operating, even after a large chunk of their money is stuck somewhere, right? And it does have a consequential effect, right? Because it has a cascading effect, because your money is stuck somewhere, you cannot pay your other vendors, or you cannot source raw materials now to complete other orders, or you cannot pay your employees the salary that they were promised, right? So all of these consequential effects are there, just because your money is stuck. So all of these things has to be considered and has to be taken seriously, is what I'm saying. So the first reason, and the first and the foremost reason, this is I keep on saying this again and again, but uh, this is still a huge problem in India, that all the enterprises are doing businesses worth of crores of rupees without any agreement, right? They just issue a purchase order which do not have any terms and conditions mentioned in them. They do not have any terms and conditions to govern their transaction, and they keep on supplying products, or they keep on giving services to the opposite party or to the other party without any agreements to govern the transaction, right? So what happens is that you do not have a record of the transaction, or how it transpired between the parties. What were the terms and conditions agreed between the parties? What were the payment terms, right? So after how many days the payment became due? So all of these terms that you cannot think of generally are very much important, and if they are not recorded anywhere in your transaction, and if god forbids your delayed payment issues occur, then it becomes really difficult for you to prove the transaction as it was, right? Because you do not have those records with you, right? Because you do not have any terms and conditions to show the independent party that these were the terms and conditions on which both of us agreed, right? So this is the first and the foremost reason for these cases to happen, because I have seen a large number of manufacturers. What they do is, I've seen cases, a lot of them, that they supply goods worth of crores of rupees, and they do it just on a pro forma invoice, and then they issue an invoice with the uh, with the challan and everything of with the challan and everything which you get for delivering the goods, right? So all of these documents are okay, and can aid you fine in a shorter run. But if the contents, or if the conditions are disputed by the opposite party in the inter-transaction, then it becomes really difficult for you, because it is not recorded anywhere, right? And you cannot say that I've given you the goods, but you have not given me the money. And the other party can say that, well, your goods were not acceptable to us. Now you can take your goods back. So just because you didn't have any time frame which was restricted for the opposite party to raise any deficiency, inconsistency in the good, or and after that period of time it is considered deemed acceptance by the opposite party, then it becomes a valid ground. It becomes a contentious ground, right, for the opposite party to raise a deficiency or inconsistencies in your goods, right? And you do not have payment terms defined, that after 10 days of issuing invoice the payment becomes due, or 15 days or 30 days or 40 days. So you have to make it clear. You also have to make it clear that what will be the interest chargeable if the payment becomes due and is not paid, right? So all of these things has to be crystallized, because I've seen a client which who delivered 80 lakhs of good, right? Goods worth of 80 lakhs rupees to an opposite party. Their uh, 80 lakh rupees was paid to him, and for delivery of some goods, right? So my client was a purchaser of the goods, right? So he paid 80 lakh of rupees to the opposite party to purchase some metals, right? And just because the pro forma invoices, the work orders that they issued, my client issued, did not have any terms and conditions, right? So just because, and it's been now 1.5 years since he's trying to realize his amount, and the opposite party is not paying him. So the only problem is that he could have gone to insolvency and bankruptcy code, which is IBC, and he could have gone to NCLT easily if only one condition was mentioned in his work order, that this is the interest that would be chargeable if you are not if you're not delivering me the materials in time, right? You cannot just take my money and just sit upon it without paying any interest, without even paying my money for one year or 1.5 years, because in 1.5 years the interest could have easily gone way above 1 crore rupees, and once it goes above 1 crore of rupees and it's not disputed, then you can easily go to insolvency and bankruptcy code and ask the NCLT to initiate the corporate insolvency resolution process. So now, in that case, the company had only two options: whether to go for insolvency of their own company, or to pay my client, right? So all of these things do not, you do not get the significance of all of these things, incorporating all of these terms and conditions in, or drawing out agreements. But then when all of these things occur and all of these things arise, then you are like, okay, it should have been done. Now I'm facing the music of it. So be very much wary of all of these things, that you do have an agreement before entering into a transaction, any sort of transaction for that matter. So what I'm saying is that you have to document or record each and every transaction. So if you're hiring employees, then I've seen that enterprises have lots of employees and lots of employees working on their payroll, but they do not have any agreement to govern those employment, right? So in all of those cases, you also cannot go to labor department if some employees takes you to a labor department, and to say them that these were, and to show them that these were the terms and conditions that were agreed between the parties, right? So all of these things, all of these agreements, you have to be very much diligent about that. You do not miss out on those things, right? So the first and the foremost reason is that not documenting or recording of the transaction, delivery of goods, material, or performance of services without any work purchase orders, not recording terms and conditions in an agreement, not adept with quick turnarounds for reserving rights, etc. The second is extended credit period. However, this is a commercial wisdom, and this has to be taken by the owner of the company or the manager of the company or the managerial key persons of the company on basis on their own commercial wisdom, that whether they should extend credit period to some enterprise which are in business with them or not. So this has to be done, and this has to be kept in mind that it should not exceed the 45 days limit, because the 45 days limit is already provided in the MSMED Act, right? So the MSMED Act says that till after 45 days the payment become due. So if the law itself imposes a restriction on the payment term to be 45 days, there is no reason for you to go well and beyond the statutory limit and to say like, okay, you give me my money in 90 days, right? Because you're already missing out on 45 days of interest if the money did not come in 90 days, right? So it is always keep in mind that it is restricted to 45 days, or if you can, if possible, then even less than 45 days, right? Because the statute mandates for the payment to be done within 45 days, right? So there is no reason for you to extend the credit period beyond 45 days. So the next one is challenges faced due to competition in the relevant market. Again, depends on the commercial wisdom of the enterprises and what businesses they are in, what operations they are in. So generally, to tackle competition and to effectively deal with all the competition and to be a profitable enterprise, what you can do is you can have a list of vendors from you source your raw materials from, or a list of customers to whom you sell your products or services. And you should not rely upon a very handful of vendors and customers. So in this way, if you have an option big enough and territorial operation, a territorial bracket big enough to operate in, right, then you can easily tackle competition in that area, because you are dealing with a larger territory and you're dealing with a larger set of vendors and customers, right? So all of these things that you can think uh, while how to tackle the competition in the market, right? And then is the no bargaining power with buyers to negotiate terms accordingly, market share reductions, alternate materials or services against that of MSMEs, etc. So no bargaining power is again a very practical difficulty which the MSMEs face, because generally MSMEs enter into contract with large corporate houses, many a times government bodies, right? In the government corporations, they have their own end agreements, uh, uh, which is called which is called template agreements, right? You do not have any power to demand negotiations and to ask for changes in those contracts, because they would go to any other MSME who would not be picky enough on the terms and conditions while negotiating with them, right? So all of these things you have to bear in mind, right? Because it is true that you do not have a lot of bargaining power while dealing with larger corporate houses or government bodies or government corporations, but you still can read out the contract or the terms and conditions that they are proposing, right? And if you think that any terms and conditions incorporated there under might become detrimental for you, or might become detrimental in the transactions that you're entering into, then you can surely ask for negotiations. And even if it means that you're gonna lose some business, then be it. Because if you're losing out on transactions, then it is better to enter into transactions, to have your money stuck and then do not get or realize that money back, right? Because then it would be huge loss. Now you're just missing out on profit, right? So all of these things you have to bear in mind. And the next one is ineffective correspondences during a transaction, lack of recorded communication between parties, reserving the right to claim liquidated damages, if any, lack of acknowledgement from the buyer regarding unequivocal acceptance, etc. Right? So, as I stated earlier, that ineffective correspondence also becomes a part of not documenting or recording the transaction, right? Because for me, each and everything has to be recorded which transpired during the transaction, whether the communication between the parties, whether some amendments were done in the delivery schedule or in the payment schedule. So all of these things have to be recorded, right? The lack of recorded communication becomes a major problem the MSMEs to prove their disputes, right? To prove their claims before the MSCFC council, right? So you have to be quick in the turnaround whenever, let's say, you have a payment due tomorrow and you did not get your payment tomorrow. So it is your duty to tell the opposite party that it was due today and I did not receive my payment, and now the interest would be applicable uh, for the delayed payment. Or you can also lay out the other consequential effects that you're facing, that if you're facing liquidity crunch, or if you're facing liquidity crunch to source materials from other vendor, or to pay your or you're failing in your payment obligations just because you did not receive payment from the opposite party, then all of these things you have to let the opposite party know that these are the consequential effects that are happening to me just because the payment was stuck. And whatever losses that you are facing from there just because the delayed payment from one party, it cannot be attributed. All the losses that you are facing due to their default cannot be attributed to you, right? So all of the losses, the consequential effects that you have faced, can be attributed to the party who was in default, right? Who did not make the payment in time. So all of these things I'm saying is that you have to reserve your rights. That you have to reserve your rights by saying that you are facing this much of losses just because you're not receiving payments on time, right? And you have to prove it before the MSCFC council. You cannot just out random state these things, right? And whatever you say and whatever you claim has to be proved in before MSCFC. Then only you will be able to get that claim, right? All of these things has to be bear in mind. If you're saying that you have faced 50,000 of losses just because 50 lakh of rupees was not made, 50 lakh of rupees of payment was not made to you on time, then you have to show that how 50,000 rupees, that how a loss of 50,000 rupees has been faced by you, right? And how did the loss occur, and whether it was due to the opposite party's failure in paying that 50 lakh of rupees or not. So if you prove that the 50,000 loss that you have suffered is just because the delayed payment of the 50 lakh of rupees, then the other party who has defaulted in that 50 lakh of rupees would also, the loss would also be attributed on that party itself. So now that party would be liable for paying you 50 lakh 50,000 rupees, right? So these things has to be kept in mind. And last one is difficulty in realizing payments from buyers, cash transactions. So cash transactions, I cannot help it. I've told this many times that do not do cash transactions as far as possible, and because cash transactions are very much a very raw way of dealing, right? Because it does not have any record, or it can be disputed easily by any of the party, right? He can any time say that he did not receive cash, that or if you paid someone cash, he did not receive those cash, or he just can outrightly deny, and you would not have anything to prove otherwise, right? If you do not have a memo or other thing to support your claim. So again, even if you're dealing in cash transactions here, you have to sign a memo, right? Because there has to be a record. Then why shouldn't you do it already in a way that it gets instantly recorded, right? So do not do it in cash transactions. Is as far simple as that. So uh, I'll move to the next slide now. The consequential effects due to challenges. We talked about the consequential effects, that if your money is stuck somewhere or is defaulted, is not paid to you on time, then it is not just the liquidity crunch that you suffer, right? There are a whole host of other things that you have to take care of, because it has a cascading effect, the consequential effects due to the defaulted and delayed payments, right? So the first one is lack of financial resources, because you were banking upon the payment that you were to receive from one party and you did not receive it. So apparently you have financial crunch, lack of financial resources. The second one is lost claims due to not having enough evidence materials on record to prove default. As I stated earlier, that if you do not have any records to prove, which can be used as an evidence at a later stage to prove how the transaction transpired between the two parties, then a lot of claims made by you would be lost because you wouldn't be able to prove those transactions, right? So the second one is this: the claims being undervalued. So again, if you do not have enough evidence to prove all the losses that suffered by you along with the claim that you're asking for, then your claims would be undervalued. You wouldn't get the losses that you suffered due to the default and delayed payment. Uh, then your claims would be undervalued. The amount that you should have gotten would not be made available to you, right? And then the other part is the loss of damages liquidated for breach of terms of the agreement by the buyer. So there are liquidated damages, unliquidated damages, right? And if for the breach of terms and arrangement by the buyer, you can a lot of times just give a pre-genuine amount in the contract itself. It also limits the liability of both the party. So let's say if there is a breach of terms and terms or the arrangement by any of the parties to a contract, then what the parties can do to a contract, that they can arrive at a certain number as a loss that they think would be genuine or they think would be reasonable as far as that contract goes. Then that much of amount which is already agreed by the parties called liquidated damages, right? So it is already liquidated in the contract. So you do not have to prove that these were the losses that you suffered in those cases. In the liquidated damages cases, you can just go and you can say that this is the liquidated damages which is already written in the contract, and you should get the liquidated damages because you just only have to prove the breach, that the terms were breached by that party, and that party would be liable to pay you the liquidated damages, right? So this thing you can also keep in mind. Liquidity crunch in the operation of business, I do not have to substantiate much on this, as I already stated that you might face liquidity crunch in employment or in or in the sourcing of raw materials or in the operation of businesses, because there are utility charges, right? Water charges, electricity charges in your plant and machinery. uh, your machines needs an operator to operate. So all of those salary, daily wage, workers wages, all of these things are dependent on the liquidity of an enterprise, right? And if you do not get your payment on time, so all of the operations get affected, each of the operations, right, in your company. So this has to be taken account into, right? Not able to realize the actual amount as reflected in the turnover generated by the MSME. So your book of profits would be very good, and your book would be doing really great, but in reality you are not getting realizing the money, right? So this difference, this stark difference would occur, that according to the accounts and books of the company or the enterprises seems to be doing fine, but then in actuality, in actual scenario, they do not have money in their hands, because all the money that they were all the receivables that were there are already stuck or defaulted by the opposite party. So this would occur. Your profitability would go down because you're already working in liquidity crunch and everything. Your employees, all of the stakeholders in your businesses are affected, so your profitability would also go down significantly, right? So you'd face minimal profitability. And then is the not taking proper and relevant professional consultations resulting in losses. So I've seen people doing kinds of things what they think is to be right. So I've seen people going and filing criminal cases in a civil recovery matter, just because they thought that they shouldn't go to an advocate or any professional for that matter. And all of these things, you do not have the idea that how detrimental it can be, because there are settled legal principles that you cannot issue or you cannot initiate a criminal proceedings just on a civil recovery or a civil matter, right? And the opposite party can any time go to the high court of that jurisdiction and get the FIR cost or the criminal complaint cost, and then again you'll be set to square zero, right? And you'll have to again initiate all the proceedings now in a better manner, and now in the genuine way. or the only available way. So please do not do things which please not do things of which you're not sure of, right? And please go out and seek relevant consultations from professionals, because these are the jobs that they do, right? And I've seen a lot of people missing out on claims, missing out on jurisdictions, just because they thought that doing this would aid in their recovery procedure, right? So this doesn't happen naturally. So uh, it is very much important to be always adept, and to take proper and relevant professional consultations from relevant professionals, right? So this has to also be kept in mind. Ineffective workforce due to lack and wastages of valuable resources, as I already stated, that your workforce would be ineffective, and your valuable resources would go to waste because you're not able to source it, or if you're able to source it in time, you're not able to make the end product or to manufacture the end product, because you have an ineffective workforce, you have a financial crunch, and all of those things. So all of these things will happen. And the legal troubles due to ignorance or no knowledge of various industry specific mandatory compliances. Now, I wanted to tell you that we are also coming up with a webinar in which we'll talk about the mandatory compliances for all the enterprises, right? So there are a host of mandatory compliances which any enterprise has to do. For that matter, if you're operating in food business operator, then the host guidelines of FSSAI applies to you, right? Labeling guidelines and all of those things. And if you're manufacturing medicine, or medicine or any drugs, then Drugs and Cosmetics Act come into play. If you're manufacturing medical devices, the regulations of medical devices come into play. And if you're an enterprise having 10 people working in your entity, be it part-time employee, be it daily wage workers, or be it full-time employee, there is one prevention of sexual harassment at workplace compliance. So that is required for every enterprises which are anywhere in India, and the fines are huge. Now I know that the regulatory bodies are sleeping; they do not conduct the inspections, they do not ask you whether you are following these compliances or not. But God forbids, even if they decided to do one day and you did not have complied it with, then you'll have to pay the fines, right? Because it is not their problem to make you understand the law or to make you aware of the law. It is your duty as a citizen, because in law you cannot say that you didn't know the law, because ignorance of law is no excuse in law, right? So you have to be aware of the legal principles, that what are the mandatory compliances that you do, right? Because all of these things, if sexual harassment complaints occur in your enterprise, and you did not have a posh compliance in place, then your whole enterprise, you would have to face a lot of it will bring a lot of disrepute to you and your business as well, your family as well, right? So all of these things you have to be aware about, right? And if you do not have these things in place, then you should go out and seek professional advice, and you please get all of these things in place, because for 1 year of non-compliance in POS is for is makes you liable for a fine of 50,000 rupees. It's just for 1 year, and the law is there. The law is there since 2013. So I do not wish that the district magistrate comes to you and asks you for 10 to 11 years of compliances, and and if you haven't done those compliances yet, then please start doing it, because any day the Supreme Court has already twice mandated all the states to ensure that these compliances are met, and the execution of it has not happened yet, right? So it is a matter of time when the district officer or the district magistrate start issuing notices, or start issuing show cause notices to you, to ensure that you have followed the post compliance or not, or the other compliances or not, right? So please be aware of the industry specific mandatory compliances, or even if not industry specific mandatory compliances, there are labor compliances, host of labor compliances if you have employees, daily wage workers working with you, right? And the as I stated, POSH Act, the POSH compliance, you have to also do POSH compliance. All of those, there are a host of other compliances, Companies Act, GST, and all of these things. So you have to be aware of all of these things, right? Otherwise, you would end up in paying huge fines and penalties, and sometimes even imprisonment in some of the compliances. Uh, so yeah, so all of these things are the consequential effects which are faced due to the challenges, right? Now we'll come to the solutions and way forward to overcome the challenges, preventive measures and solutions to be adopted internally in an enterprise. So as I stated, if you have a website and you do not have a privacy policy uploaded there, or if you do not have a terms of use uploaded there, then please go and please draw out these things, draw out agreements. If you're a manufacturer, draw out an agreement as to how, what are the conditions and terms would be applicable for delivery of your products, right? all of these things uh, all of these things you have to take care of, right? So all of these things are the preventive measures and solutions. Just give me 1 minute. I'll take 1 minute break because someone's here at the door. I'll just see and come. So just give me 1 minute. I'll be back. So yes, so I would read out the preventive measures to enter into a written agreement, recording the understanding of terms between the parties, duly executed, properly stamped and notarized. So I've seen people making agreements, sharing those agreements, but they do not sign those agreements, right? They do not exchange the hard copies within themselves. They do not go and they do not get those agreements properly stamped or notarized for that matter. So all of these things, please bear in mind that making agreements is good, but those agreements has to be executed, stamped, and then notarized also, right? So all of these things, please keep in mind. Work purchase order to be raised under such agreements. So I've seen, I was talking about a manufacturer who is manufacturing some products, and he has to draw an agreement, a master agreement on basis on which he would supply their products to any other vendors or any work orders, right? So there has to be an agreement basis on which all the deliveries are made. So you have to refer those agreement in your invoices. You have to share those agreement or memo with the opposite party before the delivery of the materials, right? So all of those agreements are necessary. Work purchase order to be shared on an electronic medium too, even if a hard copy of the same is raised. Please ensure that your communication, your exchange of materials, your exchange of documents are happening on mail. It is not hand to hand exchange, because again the opposite party or the any of the parties can say that they did not receive the said document if it has changed hands, right? And there is no recording of it in electronic medium, right? So please bear this in mind. Recording each and every transaction, its terms, obligations, applicable interest upon delayed payment, consequences of breach, force majeure, indemnity, dispute resolution clause. So if dispute happens, you can always restrict the jurisdiction of a dispute resolution to a one state, right? If you're let's say delivering products from Bihar to Haryana, now the opposite party, now in law, the opposite party or you have choices of jurisdiction to choose with. Now you can file your case in Bihar, you can file your case in Haryana, you can file your case anywhere where the cause of action is stated to have arisen, right? But if you restrict in your dispute resolution clause that only the courts in Bihar would have the exclusive jurisdiction to deal with all the disputes arising out of this agreement, then you are at your own home, that you have the benefit of being in Bihar and doing the cases, right? So let's say if you did not have this clause, and the opposite party had filed a case in Haryana, then you'd have to go and hire an advocate in Haryana. You'd have to go to Haryana for each and every hearings. So it would bring a lot of trouble for you, right? So all of these clauses, be it insignificant for now to you, but are very much significant in a longer run, or if you look at it holistically, right? So is what I'm saying, that all of these terms, all of these clauses has to be incorporated in your agreement. The unequivocal acceptance of work purchase order if no defect, protest, or demur has been pointed out by the buyer. You can restrict a time frame. So let's say in 15 days, if the buyer has not pointed out any defects, protest, or inconsistencies in the materials or the services that isn't provided to the opposite party, or to that party, then it would be deemed as a unequivocal acceptance, that it would be deemed that you have accepted our services or our materials as it is, and you do not have any problem with it. So all of these things you have to incorporate in your agreement, so as to when you enter into a dispute or dilated payment cases, you can easily rely upon these documents, these clauses, to the adjudicating body, and say, look, these were the terms on which we both agreed. Now the party is not adhering to the conditions and the terms on which we have agreed, and please rule out the and please award me the claim that I'm asking. And if you have all the recorded transaction, or all the evidences that is required by the adjudicating body to reach out and to figure out the terms and conditions between the parties, then it becomes easy for any party to realize their claim, right? Because delayed payment can happen to anyone. Delayed payment cases, you are transacting with Tata, you're transacting with Reliance. All of these companies enter into delayed payment cases. So it's not like that if you have a very effective mechanism in place, then these issues wouldn't even occur, right? It might occur, but then if you have all these mechanism in place, then it becomes really easy for you to wrestle out your way, or to realize your claim in these proceedings too. And if you do not have, it becomes really difficult for you to do so. So all of these things would help you or aid you in a longer run, is what I'm saying. The next one is being adept with communication, reserving of right to claim damages, if any, receiving acknowledgement of the due amount from the buyer, taking steps to resolve issues before the claims are barred by limitation, follow-ups on delayed payments, balance payments, intimation of the applicable interest, not diluting its rights. So I've stated all of this earlier, that you have to be adept with communication. Everything what is transpiring in the transaction has to be recorded, has to be done on an electronic medium, preferably mail. Then if you are facing any losses, then you have to reserve your rights to claim those losses to the opposite party. You have to let know the opposite party that these are the losses that you are facing due to the default payment, which is their breach, so to speak, and the losses would be attributable to them along with your original claim, right? So all of these things have to be you have to be adept with your communication, right? You have to be adept in adhering to the turnaround times in which you reserve your rights, and etc. So and one point I would like to highlight again is the point of limitation. I have seen a lot of MSMEs. I do not know why this keeps happening to MSMEs. They keep on sleeping on their delayed payment cases. I don't know, maybe because they do not have any financial, they are facing again the financial crunch to pay out the professionals like advocates and everything to take forward their cases. But then if you're not at all concerned with the limitation period, then there might be chances that your claim would never be realized by you. So the limitation in generally recovery cases, if I have to say to a layman, I would say it is 3 years generally, from the date on which the cause of action has arisen. Now it becomes complex for me to make you understand the cause of action, but in simpler terms, let's say if the payment term was for 45 days, and on the 45th day you have not received the payment, so you can say on the 45th day the cause of action has had arisen, right? To for you to go to the court. So you have to take this in mind that you only have 3 years, so to approach the court and to realize your claim. And if you cannot, then you can never go to the court and can ask your court and can ask the court to adjudicate on your dispute, because your claim would be barred by limitation. And there is one section, section 18 of Limitation Act, which I would talk to you about. It says that within the limitation period, so let's say in 2020 January, your cause of action had arisen. So in January 2023, the limitation would get ended, right? So in between 2020 to 2023 January, if the opposite party acknowledges again that yes, this is the dispute, and I am acknowledging this amount of money is payable to you and I'll pay you this amount, then from that acknowledgement, the period of limitation starts afresh. So, but the only condition is that the acknowledgement should come within the first limitation period. It cannot come, an acknowledgement cannot come in January 2024. The acknowledgement has to be within the original limitation period. So the acknowledgement has to be before January 2023. Only then the period of limitation would start afresh from that acknowledgement, right? So please take this in mind and keep this in mind, sorry, and we'll move to the next slide. What are the things, the modalities that you can adopt so that these issues do not arise? First is like taking proper consultations from relevant professionals to have a legal secretarial audit and verifying the industry specific mandatory requirements, compliances under different statutes, incorporating effective ways to execute agreements, communications, follow-ups, receiving acknowledgement against purchase work orders, and delayed payments. As I stated earlier, all of these things has been written down and needs no substantiation, I guess, because we have talked about it already. And the next one is to carefully assess damages clauses in the agreement, computation of claims under various heads such as price escalation, overhead charges, machinery and workforce idlement charges, etc. So this is generally for construction and EPC contracts, engineering procurement contracts, and construction contracts. So you have to, while asking for your claim, you have to also generally carefully assess the claims in the agreement. You have to compute the claims under various heads such as the price escalation. If the agreement is not ended in the original time frame, and you had to work, let's say the agreement was for 2 years and you have to work for 5 years, and you worked for 5 years, and after the 2 years the prices of the materials that were used in the construction has increased, then you're entitled to receive the differential amount of the purchase amount, right? So all the escalation that were made in the prices of the materials, uh, you would be entitled to receive. So all of these computation has to be done carefully. The overhead charges has to be computed carefully. The machinery and workforce idlement charges has to be computed carefully. All of these things, while doing, you will require professional advice and aid, and you should not shy away from doing it, because a lot of time people miss out on huge claims which are arising under these heads, right? And the next one is to be well versed with all the schemes, benefits, policies by the government affecting MSMEs. So as I stated earlier, it is the MSMEs who has to be aware, who has to be careful, diligent in all of these schemes, benefit, policies by the government, which are affecting them, right? Which should go a long way in aiding them, assisting them, facilitating them. Generally, what the Udyamita helpline does is to collate schemes, benefits, policies by the government affecting MSMEs, and to bring out professional uh, professionals who would educate and disseminate their knowledge to the MSMEs. So I would highly suggest you to follow this Udyamita helpline. Udyamita helpline as an enterprise, and to be adept with all of these schemes and benefits that are made available to you by the government. So you have to know about them, right? And the next one is to safeguard the interest of the business, creating strategic assets, raising proper invoices with GSTIN, UN, PAN, be updated with the statutory tax or other filings. So I've seen in tax, I do not do a lot of tax matters, but in tax, there is a requirement for you to mention the address of your company, your GSTIN, your UN, your PAN. All of these things you have to you have to bear in mind. You also have to necessarily mention your MSME registration number, or the type of MSME that you are in your invoices, so that the opposite party could not ever say that they did not have any idea whether you are an MSME or not. So all of these things you have to bear in mind, keep in mind, and to follow it also. And creating strategic assets also means that creating intellectual property rights. So if you have invented something, please go out and file a patent. If you have a business logo which has generated or garnered goodwill in the market, then please go and protect that business logo in trademarks. You have and if you have bear expenses in uh, making your advertisement campaigns or your website, then please go and get those protected in Copyright Act. If you have a product or a design which is not for utility purposes but for aesthetic purposes, like the Coca-Cola bottle, or any bottle for that or for that purpose, or for any product in which a design is there and it does not help with the utility, go and get that design protected in Design Act. So all of these things which you do create strategic assets. These are not expenses, legal expenses that you would like to say, but these are assets that you are making, because these can also be sold off, right? These can be assigned to the opposite party in exchange of consideration, right? So these are the assets, so to speak. So always keep in mind that you are the only one who would have to create strategic assets, safeguard the assets of the company by filing for trademarks, patents, designs, and everything, right? So to create outreach with online presence, new clients, buyers, proper reasonable pricing, strategic business decisions, proper invoicing. I do not think that I do have to substantiate on this. If you have an online outreach in today's era, and I do not think that I should go on and count the benefits of having an online presence, right? Everyone knows in today's era that having an online presence is far more better than having an offline presence, right? So please do keep in mind all of these things, right? So being adept with follow-ups for payments, I do not think that we have to substantiate again upon this, because you have to follow up every time when the payment is due and you are not receiving payment from the opposite party or the other party. You have to remind them that their payment obligation has ended, and and you have to follow up for your own money, right? So it's as simple as that. Acquiring a post-dated check for the bill raised as a security measure to avoid delayed payment. Now, this is a very ingenious way to protect your delayed payment cases, right? Because I have seen people taking post-dated checks just as a security measure for ensuring timely payments, right? And if they do not, if they fail to make you the payment within time, you can any time go to the bank and produce these checks that you already received from the opposite party of a post-dated. Preferably after the payment term has ended, and if the opposite party did not have sufficient funds in their account, then the check would be bounced, and criminal liability would ensue on the company, on the enterprise, as well as the director or the signing authority of the check, right? So it is a strong arm twisting mechanism for someone to have, and if they do not receive the payment on time, you can coerce the other party in making the payment, because you have the post dated checks, and if he does not pay you or does not keep sufficient funds in his account, then he very well knows that a criminal liability would ensue if the check gets bounced, right? So I will move to the next slide now. Now we'll come to the resolution of disputes. What we do such disputes have already occurred, right? So the external solutions are the recourses from MSCFC as per the provisions of MSMED Act, right? We'll talk about some of the major provisions of MSMED Act, uh, generally relating to dispute resolution mechanism. Then we'll talk about proceedings under Section 138 of Negotiable Instrument Act. Then we'll talk about insolvency and bankruptcy code. Then we'll talk about arbitration in general, and then we'll talk about civil suit for recovery of money. And civil suit in itself includes also summary suits and summary judgments. So uh, let's move ahead with the solutions, external solutions. The first one is the dispute to MSCFC. Now, liability, the section 15 is liability of buyer to make payments. Now, this is the section on which in under which the act makes it very clear that once a buyer has received the goods, or a service provider, now it has the liability to make payments to the MSME, right? MSME enterprises. In section 16, it states the date from which and rate at which interest is payable. Now, this is a very important section. This section states that from the 45th day of making the delivery, the amount becomes due, the payment becomes due to the buyer, due from the buyer to the supplier, right? And if that payment is not made within the 45 days limit as given under the act, then it says that interest rate would be applicable on such payment. Now, what is that interest rate? It states that interest rate, whatever notified by the RBI for that time, 3 times of that interest rate would be applicable, compounded on a monthly basis. So it is compound interest, which is on monthly rests. It is not even annually. So it is on monthly rests, and it has to be 3 times the notified bank rates. So I guess it was last around 6.5 or 6.25, which was notified by the RBI. So 3 times that comes anywhere between 18.75 to 19.5%. Compounded monthly rests, compounded monthly rests. So this is the interest rate upon which uh, this is the interest rate which is applicable on the delayed payment. And if you ask for your claim before the MSCFC and you have registered as an MSME, then there is no reason for you to not get this interest component, right? The section 18 is reference to MSCFC. How do you file a case, right, before the MSCFC? So there is a format now, uh, uh, which is uh, which is filed online in the MSME Samadhan portal, and you have to fill out certain details. You have to upload the purchase order or the invoices, and then you have to mention the amount and everything, and then you have to file your case, which is called the reference application. And once you file a reference application, your application gets accepted, and opposite party receives an instant notice saying that this case has been done by the buyer for demanding a payment of this amount. Now, the opposite party has two options: whether he can make the payment or he can dispute the claim. If he disputes the claim, saying that I do not think that I have the obligation to pay, or I have the liability to pay the opposite party, and it is not the correct amount that the opposite party has demanded, or anything of that sort, then he can issue a response to the MSCFC Council saying that these are the reasons why he thinks that he should not pay, and the MSCFC would forward you the reply received by the opposite party. And then if you think that it should go into dispute, or it should further go for uh, proceedings under the MSCFC, then the first, it is referred to conciliation proceedings, where both the parties are called to the office, and then they are made to sit together, they are made to talk to each other, and to figure out a way to resolve it mutually, right? And if it is resolved mutually, then it is well and good. And if it does not get resolved mutually, then further it gets referred to arbitration before the same council. Now, in arbitration, what does the council do? It asks you for a statement of claim in which you would write down all of your claims, consequential damages, liquidated, unliquidated damages, and you'll say that why you should think with all the evidences that these claims should be made available to you from the opposite party, and the opposite party would give their defense. Both the parties would argue, and then the independent arbitrator or the independent counsel, generally they are a group of people, uh, they would decide whether, basis on the arguments and the pleadings of the both the parties, they would decide whether they have to pass an award or not, whether they have to award you the claim that you have asked or not, right? So this is how the procedure in a nutshell go in MSCFC, right? So the other two most important sections are application for setting aside decree, award, or order. In case you have gotten an award to yourself from the MSCFC. Now, what did the opposite party do earlier? That they used to go into appeal, and they used to go till the Supreme Court, and it used to take around 5 to 10 years more after you have gotten yourself a claim amount from an arbitral tribunal to actually realize, to actually finalize the matter, because in appeal they can very well go to Supreme Court, right? They would first go to the civil court. Depending upon the pecuniary jurisdiction, they can also go to the high court, and then they go to the Supreme Court. So all of these things takes time, right? And what this section ensures is that if a party has to appeal an award or order passed by the MSME in which an award is given, like in which a claim has been accepted, and said that the opposite party has to pay 1 crore of rupees to the claimant, then without submitting 75 lakh of rupees to the appellate authority, the opposite party cannot claim that award or appeal. So any claim amount that have been awarded in the arbitration award, if it has to be appealed, 75% of that claim amount has to be mandatorily deposited before the appellate authority, so that your appeal can be entertained. So it is not even decided on merits. It is entertained only after when you have deposited 75%. So what the opposite party do, generally opposite parties would not go in appeal, because they anyway have to pay the award amount, right? At least the 75% of it. So they generally do settlement with the claimant and everything. So it is a very beneficial provision for the claimant, because they won't have to wait now just because the opposite party is going to appeal it before the every jurisdiction that there is, right? So in section 24 is overriding effect. So uh, MSME Act was in 2006, I guess. Yeah, it was brought in 2006, and for every other act which was brought before MSME Act, now the MSME Act in section 24 has an overriding effect, right? So when you see, even if you have an arbitration agreement, right, an independent arbitration agreement between the parties in an agreement in which you have in a contract in which you have signed and everything, still you can choose that you can go for arbitration or you can go for MSME, right? Because Arbitration Act was in 1996 and the MSME is in 2006, right? So the MSME Act has precedence over the Arbitration Act. So even if parties have an independent arbitration agreement, it is not necessary for them to go for arbitration only. It is the claimant who will decide whether he wants to go for MSME reference cases or not, right? So these are the this was the in a nutshell proceeding of how MSME reference cases and how the proceedings uh, go, right? Now we'll come to the recourse after dishonoring of checks, which is pretty much simple. It is in section 138. It says dishonor of checks for the reason of insufficient funds in the account is a criminal offense as well as a civil wrong. In section 39, the presumption is always on the holder of the check, so whom the check is made, or the drawee of the check, right? Uh, so the check holder always has the presumption that the check was given to him in lieu of discharging any liability, right? So it is always presumed that there was a liability. In the furtherance of extinguishing that liability, the check was produced by the check was produced to the holder, right? And section 142 is the cognizance of offense, who will take the cognizance and everything. Explanation, important things to remember before resorting under NI Act jurisdiction, which is under section 142.2, which is always where the bank is situated, right? And the procedure is complaint, metropolitan, or JMFC, right? So you have to furnish a complaint before the metropolitan magistrate or the judicial magistrate first class, depending on who does have the jurisdiction in your area. And you have to also give them a mandatory notice of 30 days whenever you receive the memo from the bank saying that this check was dishonored due to insufficient funds. So then within 30 days you have to issue a notice, which is mandatory in law, to the opposite party to ask him to make you the payment. And if he does not make the payment within 30 days, you have to give him another 10 days or 15 days. 10 or 15 days, and then you can go and file your case under section 138, right? Action can be taken both against the entrepreneur and signatory of the dishonored check, right? As I already stated, that the company on whose name the check is issued or the director who has signed the check, both would be equally liable and simultaneously be liable for the dishonoring of check. So this ensures criminal liability, right? So this is a strong arm tactics by which you can make the opposite party pay the delayed payment, and any failure would result in imprisonment, right? So in this case, it's a strong arm tactics. If you have a post dated check, it is very well and good, and you should not hesitate in going and producing those checks, post dated checks, if you have not received your payment in time, right? So that the opposite party also faces the music, right? The next slide is recourse under insolvency and bankruptcy court. So this is not a actual recourse, so to speak, because this is whole another dimension. Because this is the case, which is this is the act which is used in not in a genuine manner as a means of recovery, but it is not act to recover the money, as NCLT have already stated time and again. But then if you know that the corporate you're going against is a huge corporation and it wouldn't go into insolvency, so anything happens, what it would do is it would try to settle your amount, it would pay you, but it wouldn't let their company go into insolvency. So these are applicable for generally reputed corporate houses or big corporate houses. And if they do have an amount which is more than 1 crore due to you, then you can take them before the NCLT. NCLT sees that whether the dispute is greater than 1 crore rupees or 1 crore rupees, and there is no dispute to the claim. Like it should not be pre-disputed that you're asking 1 crore rupees and the opposite party has time and again stated that only 50 lakh is rupees, for 50 lakh rupees is due according to my accounts, and you are saying no, according to my account 1 crore rupees is due. So this amount becomes disputed. So you cannot take a disputed amount to NCLT and ask the NCLT to initiate the insolvency resolution process against a company. For a company, the amount has to be crystallized. It shouldn't have to be disputed. And if it is above 1 crore and a default is there, then there is no reason for NCLT to dismiss your application, and they generally initiate the CIRP of the company. Now, what happens is, if the CIRP is initiated and the corporate house is big, reputable, and everything, what they will do is they will come and they'll settle you the amount, or they'll enter into a settlement with you, or they'll easily pay you the dues. But in sometimes, if the company is already defaulted and have no means to pay you, then it becomes already a detrimental recovery mechanism also, because being an operational creditor, the first one who has gone to the NCLT to initiate the CIRP of the company has to bear the CIRP cost, which is again 2 lakh rupees. You'll have to bear for the company's CIRP. And once the company is sold to any other prospective buyer, or if not sold to any prospective buyer, then liquidated, and all the receivables of the company would then be distributed accordingly to all the creditors. So a lot of time you'd see that an operational creditor who had, let's say, 2 crore of rupees, even after liquidation and everything, were only able to realize 20 lakh of rupees. Now it might happen, because there is no guarantee for you to receive all that amount from a company which is due towards it, because they do not have that much of assets, right? So everyone has to bear the haircut, right? Has to bear the loss in pro rata basis, uh, as per their claim amount, right? So you have to take this into account, because this is very much specific as per the circumstances and facts of the case. I wouldn't suggest you to uh, liberally go to insolvency and bankruptcy and to invoke IBC for recovery of dues. And it has to be thought of. It has to be talked to some relevant professional, whether IBC is good, or going to MSME is good, or to going to summary suits is good, because IBC does not guarantee you the 100% realization, right? Which no other act or recourses guarantees, because it always depends on the assets that the company has, or the assets that the other party has, right? That's the only limitation. But then you have to keep in mind that this is not a classic recovery mechanism, but it is more of a replacing management of a company, so that the company remains and the faulty management goes. So the uh, uh, the basic point of insolvency and bankruptcy being drafted is this: is it's not recovery of money. So please see whether in the given facts and circumstances IBC is an option, or if it is an option, would it be a better option than MSME or civil suit or any other mechanism? And talk to a professional, talk to somebody who knows all of these things, and then decide, right? So I guess we have talked enough about IBC. Now we'll talk about the resolution by way of ADR. Now the arbitration, it is arbitration, right? So even in MSME, the procedure is followed is arbitration only. And if you have an arbitration agreement apart from the MSME registration, or if you did not have MSME registration and you have an arbitration agreement, then the only recourse that you have is to invoke the arbitration, right? Is to invoke the arbitration. And So there are some of the important provisions that we'll talk about. In section 11, you go for appointment of arbitrator. As a you must have seen a lot of times the arbitration agreement also talks about who will be the arbitrator. It cannot be done, because in Arbitration and Conciliation Act, the Supreme Court has recently stated that one party cannot decide upon the arbitrator who will be the arbitrator. There has to be a contribution from both the parties in appointment of an arbitrator. So you appoint an arbitrator under section 11. In section 16, if you have any questions regarding jurisdiction or applicability, arbitrability of the dispute, then you raise it in section 16. Section 17 is interim measures, that you think that there is something interim that has to be entertained by the arbitral tribunal or by the court. Then section 9 and section 17 is interim measures. If the arbitral tribunal is not constituted, you can go to the court in section 9 for any interim measures that you require. Or if the arbitral tribunal is already instituted, you can file a section 17 application, so to get that interim measure that you want, right? In section 34, you go and challenge the award, which is highly restrictive, because arbitration awards are not treated as appeal, right? The court does not sit as a court of appeal while deciding challenge to the arbitration awards, right? Because there are a very limited grounds on which the arbitration awards can be set aside. So in section 34, it talks about the grounds on which the arbitration award can be set aside. Conciliation is in section 61 to 81 of the Arbitration and Conciliation Act. The filing of claim, how to file statement of claims and defense. As I stated earlier, you have to lay out all of your claims, all of the heads in which you are asking claim, how how these losses occur, how these losses are related to the default of the other party. If you are if you are if you go and if you successfully prove all of these things, then you might just get your claim as was demanded from the arbitral tribunal, right? So these are the most important provisions in arbitration and conciliation, right? And it is another recovery mechanism apart from MSME, because in MSME you do not get to appoint arbitrators. It is always MSCFC which decides, right? So the procedure is same. The provisions are the same. The procedure are governed by the Arbitration and Conciliation Act, but then it is a bit different in procedure also. So let's move to the next slide now. Now, it's the last is the classic recovery mechanism, civil suit for recovery, civil procedure code. In order for you institute a suit, in order 37, you institute summary suits. Now, suits and summary suits are very much different. Summary suits is a way in which you can expedite the recovery process, because summary suits under Order 37 is when you have a claim which is not disputed at all, and which is crystallized clear. It does not have any scope for a dispute or any scope for the opposite party to even lead a defense, right? Then you file a summary suit before the court. The court within 10 days asks the opposite party to appear and to prove that why he should be given an opportunity to defend this case. So if he does not successfully satisfies the court that he should be given an opportunity to defend this case, because all the records and everything speaks volumes against the opposite party, and then the summary suit goes ahead without the defense, right? So it goes against the principles of natural justice. It states both the parties have to be heard. In this case, the opposite party has to be heard only once, and the court decide whether he has to be given an opportunity to defend his case at a later stage, or on a going basis or not. And if he does not satisfies the court that he should not be given a opportunity to defend his case altogether, then the court, basis on your documents, gives you an award or decree, right? So and suits are normal suits. So let's say in summary suits, the opposite party comes and he satisfies the court that he should be given an opportunity to defend because there were materials which were not brought on record by the claimant. Then what would happen if the court gives him the opportunity to defend his case? Then the summary suit generally gets converted into a normal suit. So how the normal suit would go? I would claim, the opposite party would come, he would dispute and everything. And basis on the arguments, the evidences, the court decides whether an amount is to be paid or not, and what amount is to be paid. So all of these things. You also have to be wary about the jurisdiction, how jurisdiction matters in these cases. So as I stated, if you being a supplier from Bihar and the other buyer is from Haryana, then it can be done in Bihar, it can be done in Haryana, it can be done in transit where the cause of action has arisen. So always keep in mind, in these cases, jurisdictions are very important, and please go and seek out relevant professional consultations before moving in any of these recovery mechanisms, right? So we'll come to the summary suits under CPC. It's again the same thing. Jurisdiction is under section 16 to 20. You can refer to the CPC for the jurisdiction places. For a land matter, the section 16 states that whether the immovable land is, the jurisdiction of the court shall always be where the immovable land is situated. For recovery cases or in anything, it is always defendant's area of residence, or where the cause of action has arisen, right? So all of these things you have to keep in mind. Limitation for claims less than 3 lakhs, okay, in written say, so commercial courts should apply. So if your claim amount is less than 3 lakhs, now the CPC would have been applicable. But now after 2015, if your claim exceeds 3 lakh of rupees and it falls under the commercial dispute definition, which is there in the Commercial Disputes Act, Commercial Codes Act, sorry, Commercial Codes Act in 2015, then you should go to the Commercial Code Act for the recovery of your mechanism. It is almost similar to CPC. The only changes are done in the timely expedition of the claims and the procedures which are done in the commercial code. So all of the process and the stages are timely are fixed on time to time basis. Uh, recovery mechanism under recovery mechanism under Commercial Codes Act, and as well as summary suits are expedited, are more fast than the general CPC mechanism, right? So now we'll talk about the quick tips and suggestions. Please also raise your hands if you want to have a one-to-one conversation with me after I finish off the webinar, and then we can move ahead with the question and answer sessions. So the quick tips and suggestions would be: always mention applicable GST, IN, UAN, PAN numbers on invoice, registered office with addresses of both buyers and MSME, amount, payment terms, interest applicable, all of these things which I have already stated. Please incorporate these in your invoices, incorporate uh, mm, important terms and provisions in your invoices, like payment terms, interest applicable, if not payment not made within time, and all of these things. If there is any rectification request or any deficiencies to be pointed out by the buyer, it has to be done in 15 days. And if it is not done in 15 days, it should be considered as a deemed acceptance by the buyer. All of these provisions that you can add. Along with it, you can add your PAN, UAN, GST-IN number, and MSME registration number, the MSME enterprise that you are, micro, small, or medium. So all of these things you can mention in your invoices, and it would be beneficial for you if you do so. And the next one is invoices communications has to be recorded, managed, as I already stated. Always manage online way of communications. Keep a record of the transactions and everything what has transpired within the transaction, right? Always have a pre-estimate of an amount which can be claimed as damages in case of delayed payments. As I stated about liquidated damages, that many a times party mention an amount that if a breach of this agreement has happened, this is the pre-genuine amount that we both think that should be payable in exchange for the losses, or in exchange for the breach suffered by the one party who was not in breach. So you do not have to prove those losses, right? You only have to prove that this is the genuine amount that we thought should be incorporated, and then you can ask the genuine amount if you are able to prove the breach of one party. So you can do so. Always try to settle amicably. This is again a very commercial wisdom, that if you have an option of settling any dispute outside court, then it is highly preferable to do so, because if you go to court or tribunal, you invest your time, your resources, valuable resources. You have to hire professionals. You have to take out time for to understand or to follow up the proceedings, right? Arbitration proceedings, be it court proceedings or anything. So it is always suggested that you should move for an amicable settlement, and do not go for a dispute just for the sake of it. And the last one is always try to safeguard interest by registering trademarks, design mandatory compliances, and update statutory filings. As I already stated, that always try to safeguard your interest by registering or creating strategic assets such as trademarks, patents, designs, and then you must be wary of doing statutory compliances and filings that are required under law, so that you do not end up paying huge fines and penalties. And I guess it was all for today. If there is any question uh, that you want to ask me, or you want to have a conversation with me, then please go ahead with your questions. Someone has raised hand. Dimple.
Dimple ji, you can ask your question.
Professor Mainak has also raised his hand. Any one of you can go ahead, sir. Any one of you can go ahead with your questions.
Hello, good afternoon, sir. Can you hear me, sir?
Good afternoon. Good afternoon. What's your
So,
name?
sir, my name is Rohit, sir.
Okay, okay. Please, Rohit, go ahead.
हाँ जी, मैं कमल मेहता की तरफ से उन्होंने मुझे लिंक शेयर किया था, एक्चुअली उनके
जी,
कंपनी में हूँ।
जी,
सो मेरा क्वेश्चन ये था कि जैसे आपने बताया कि 3 इयर्स ही इसमें एप्लीकेबल है, आप 3 साल के अंडर में ही आप उसको कर सकते हैं क्लेम,
जी,
राइट सर?
हाँ,
तो हमारा जो केस है वो किसी कंपनी के साथ लगभग 2018 से है और 2018 से कुछ पेमेंट्स नहीं करी हैं और
हम्म,
उनके साथ जो कॉन्ट्रैक्ट था मेरा वो
हम्म,
2021 में अगस्त में खत्म हुआ है।
अच्छा, ओके,
तो
ओके,
जैसे आपने ये भी बताया कि कुछ अमाउंट का लिमिटेशन भी है कि आप इससे ज़्यादा नहीं कर सकते। हमारे
हाँ जी,
6 लाख का अमाउंट बन रहा है जो
हम्म,
एमएसएमई के लिए हम करना चाहते हैं।
ओके, ओके। देखिए, लिमिटेशन जो होता है ना, वो आपको एक और चीज तो मैं आपको अभी ये बता दूंगा कि आपके लिए एक ज्यादा अच्छी चीज ये है कि ड्यूरिंग द कोविड टाइम जो
जी,
2020 से है, आई आई गेस 2020 से 2022 का जो टाइम था, वो पूरा
जी,
लिमिटेशन के परव्यू से एक्सक्लूड कर दिया गया था सुप्रीम कोर्ट के द्वारा। कि वो लोग कहे थे कि ये लिमिटेशन काउंट करते समय ये जो 2 साल है वो आप काउंट ही नहीं करेंगे। ठीक है, तो आपका वहां पे 2 साल बच जाता है एक बार के लिए तो। लेकिन मुझको एक बार देखना पड़ेगा, हम लोगों को एक बार देखना पड़ेगा कि कॉज ऑफ एक्शन हम लोग कहाँ से दिखाते हैं। ठीक है,
जी,
ये सब बहुत सारी कंटेंशियस चीजें होती हैं। आपको देखना पड़ेगा कि किस दिन किस डेट पे कॉज ऑफ एक्शन अराइज हुआ था आपका,
जी।
किस दिन पेमेंट ड्यू हुई थी, और वहां से हम लोगों को जोड़ना पड़ता है। ठीक है, तो
सर,
अब जैसा आप बता रहे हैं कि 2021 में आपका जो था मेन अग्रीमेंट खत्म हुआ था, तो आई
हाँ जी,
गेस कि वी कैन डू इट इन दैट वे कि हम लोग 2021 से इसको जोड़ना शुरू करें, और 1 साल का हम लोग एक्सटेंशन, वो तो वैसे ही मिल जाएगा सुप्रीम कोर्ट के जजमेंट के हिसाब से, क्योंकि वो कहता है कि आप कोविड का टाइम लिमिटेशन को कंप्यूट करने में नहीं ले सकते।
जी,
तो उसके बाद हम लोगों को देखना पड़ेगा भाई, हमारे पास आई गेस आपकी ऑलमोस्ट खत्म होने वाली होगी लिमिटेशन पीरियड। सो प्लीज
श्योर,
गिव द डॉक्यूमेंट्स टू मेघा, शी विल फॉरवर्ड इट टू मी एंड आई विल लुक एट I'll look at it. I'll look at
डेफिनेटली
your
सर।
documents and I'll see whether anything can be done or not.
एक बात और करना कहना चाहता हूँ कि जो
हाँ
हमारा
जी,
कॉन्ट्रैक्ट पीरियड जो शुरू हुआ था, स्टार्ट हुआ था 2015 से शुरू हुआ था
ओके,
और 2021 तक चला है, तो वो एक साथ इनवॉइसेस के हिसाब से पेमेंट नहीं करते थे, बल्क मतलब एक साथ करते थे
समझ गया
कि
मैं, समझ गया।
हाँ,
रनिंग अकाउंट में पेमेंट होती थी आपकी,
हाँ,
समझ गया
हाँ
मैं।
जी।
हाँ जी,
तो
हाँ जी। तो 2021 से ही हम लोग जनरली कोशिश करेंगे कि कंप्यूट करें अपना लिमिटेशन।
वी कैन नॉट फाइंड आउट कि कौन सी पेमेंट कब हुई है, तो ये
बिल्कुल,
थोड़ा
बिल्कुल, बिल्कुल। I get your point. I've handled many disputes with running account, वो पेमेंट
जी,
टर्म्स, जिसमें कोई एक इनवॉइसेस के अगेंस्ट पेमेंट नहीं आती है, लमसम पेमेंट आती रहती है, और
जी,
वो वैसे ही चलती रहती है। तो उसमें जो जनरली वैसे लिमिटेशन कंप्यूट होता है जब लास्ट में आपका अग्रीमेंट खत्म हुआ और
जी,
उसके बाद जो पेमेंट ड्यू रही। समझ रहे हैं
जी,
आप? क्योंकि
जी सर,
क्योंकि कॉन्ट्रैक्ट एक्ट में एक ऐसा भी चीज है जिसमें ये कहते हैं कि अगर मान लीजिए 2018 में आपका कोई एक इनवॉइस पेमेंट ड्यू था, ठीक है,
जी,
और
जी,
वो तो कोई एक इनवॉइस के अगेंस्ट पेमेंट कर नहीं रहे, और ना ही
जी,
बता रहे कि ये पेमेंट जो है ये इस इनवॉइस के अगेंस्ट आया है, या ये जो पेमेंट है या ये इस इनवॉइस के अगेंस्ट आया है। तो इन
बिल्कुल,
कॉन्ट्रैक्ट एक्ट आपके पास एक अपर हैंड ये होता है कि अगर कोई आपको ये बोल के पैसा नहीं दे रहा कि ये
हुँ,
किस अगेंस्ट, किस चीज के इन ल्यू और फर्दरेंस में दिया गया पैसा है, तो वो आप
जी,
उसको अपने हिसाब से एडजस्ट कर सकते हैं। आप उसको प्रिंसिपल में एडजस्ट कर सकते हैं, आप उसको
हुँ,
इंटरेस्ट में भी एडजस्ट कर सकते हैं। तो
ओके सर,
ये सब चीजें हैं जो आपको एड कर सकती हैं, बट आई हैव टू look at the documents for a more holistic understanding.
श्योर
Rohit.
सर। सो मेरी साथ बात हुई होगी, कर्नल मेहता जी से बात हुई होगी आपकी
जी,
या आपकी
जी,
टीम
पहले
से
हुई
बात।
थी, हाँ।
हाँ, तो उन्होंने मुझे लिंक शेयर किया था आपका कि आप ज्वाइन करिए, अगर कुछ क्वेश्चन है तो आप करिएगा, फिर देन देखते हैं, हम बात
बिल्कुल,
करेंगे फिर।
बिल्कुल, बिल्कुल।
सो आपने जितना समझाया वो बहुत अच्छा था, मतलब काफ़ी अच्छी इन्फॉर्मेशन थी, जो और भी कहीं इंटरनेट में कहीं भी नहीं मिलेगी। सो इसलिए मैंने आपको पर्सनली मैंने बोला कि कैन यू शेयर योर प्रेजेंटेशन। अगर बीच में कहीं मिस हुआ है कि कॉल आ गई, क्योंकि फोन पे ही लॉगिन था, सो इसलिए थोड़ा सा अगर प्रेजेंटेशन भी आप शेयर कर सकते
This gets
हैं।
uploaded on YouTube as YouTube videos. You can always go and find our videos on YouTube. So that won't be any issue for you.
ओके
So,
ओके,
हाँ.
नो इशू।
So please give the documents to Megha. I'll have a look at it and I'll advise you accordingly.
श्योर, डेफिनेटली सर, थैंक यू सो मच सर।
Thank you, Rohit. Thank you.
Mr. Saurabh ji. Mr. Saurabh ji, you can ask your question. Satish ji.
So anyone from
Am I
the
audible,
people
sir?
who, yeah.
Okay. So my name is Saurabh. I am from Haldwani in Nainital, Uttarakhand.
Hi,
I have
Saurabh.
I have a small query, Shashankji, with regard to the Negotiable Instruments Act, post-dated checks.
Mhm.
Apologize अगर मैं फ्री की कंसल्टेंसी लेने के डोमेन में जा रहा हूं, बिकॉज दैट इज नॉट माय इंटेंशन। सर, अगर कोई क्लाइंट जिसने पीडीसी हमें दिया हुआ है, मान लीजिए टाइम उसने जब हमने चेक प्रेजेंट किया तो स्टॉप पेमेंट लगा दिया, या मान लीजिए कि हमें पीडीसी दिया हुआ है लेकिन उसने रिपोर्ट किया कि दोस चेक्स हैव बीन स्टोलन या misplaced या
Then
लॉस्ट।
you can then you have a classic case of fraud. You
Hello.
can go for a criminal liability. You go and you file an FIR against that party.
हेलो,
तो इधर
थैंक यू।
लेकिन
हेलो सर, मैं एक क्वेश्चन पूछ सकता हूँ?
Yes, please.
सर, मेरा क्वेश्चन है, एमएसएमई में एक फर्म रजिस्टर्ड नहीं है और
Okay.
पहले हमने कराई नहीं थी, और माल सप्लाई करने के बाद क्या हम एमएसएमई में रजिस्टर्ड करा के केस फाइल कर सकते हैं?
No, you cannot do so. It was recently decided by Supreme Court in Silpi Industries. The case name is Silpi Industries, in which the Supreme Court has stated specifically कि आपके रजिस्ट्रेशन के बाद से ही कोई इनवॉइस का, अगर आपका कोई इनवॉइस जो है डिलेड पेमेंट जाता है, तो द फर्स्ट प्री रिक्विजिट इज कि आपको पहले से रजिस्टर्ड होना है एमएसएमई में।
ठीक है।
आपके पास फिर दूसरे रिकवरी ऑप्शंस है जो कि मैंने बताए, सिविल सूट, आर्बिट्रेशन अगर है तो उसमें।
जी सर। और सर, एक सेकंड ये है कि जैसे एमएसएमई में केस फाइल कर देते हैं, उसमें डेट ही नहीं लगाते हैं, वो 6 महीने तक, 8 महीने तक।
ये देखिए, ये जो है ना वो थोड़ा प्रैक्टिकल सिचुएशन है, स्टेट टू स्टेट पे डिपेंड करता है। एक तो हर स्टेट अपना अपना वो बनाती है कि कैसे वो करेगी। जैसे
तो उसके रिगार्डिंग जैसे अब वो पुट अप ही नहीं कर रहे दोबारा से।
हाँ, देखिए मैं आपको बताता हूँ कि ऐसे सिचुएशंस आ रहे हैं बहुत, क्योंकि बहुत सारे जगह पे, जैसे कि मुंबई में है हमारा एक रेफरेंस, वहां पे 1 साल से फाइल्ड है, अभी तक उसमें कुछ भी नहीं हुआ। तो अब उसमें आपको देखना पड़ेगा कि आपको कितने पैसे चाहिए, आपका कितना पैसा का क्लेम था। अगर मान लीजिए 5-6 लाख रुपए का ही क्लेम था, ठीक है, तो अब आपके पास ऑप्शंस है, ऐसा नहीं है कि आपके पास ऑप्शन नहीं है। यू कैन वेरी वेल गो टू हाई कोर्ट ऑफ योर स्टेट, जहां पे आपने एमएससीएफसी जहां पे फाइल किया है, और आप हाई कोर्ट को बोल सकते हैं कि देखिए साहब, एक्ट में तो लिखा है कि 90 दिन में इन लोगों को करना है, लेकिन ये अभी तक कुछ कर नहीं रहे। तो हाई कोर्ट उनको तुरंत पुल अप करेगी। लेकिन फिर वही बात है कि आपको वहां पे हाई कोर्ट का भी खर्च उठाना पड़ेगा अब साथ में। तो आप देखिए कि आपका जो पेमेंट है वो कितना ज्यादा आपको चाहिए, कितना नहीं चाहिए, कमर्शियल विजडम पे डिपेंड होती है।
अगर हमने जैसे एमएसएमई में फाइल कर दिया, वहां पर डेट नहीं लग रही, तो क्या सिविल सूट फाइल कर सकते हैं उसको विड्रॉ करके, या क्या पोजीशन है?
विड्रॉ करना पड़ेगा, कर तो सकते हैं, यस कर सकते हैं, बट देन यू विल हैव टू विड्रॉ इट। यू कैनॉट साइमल्टेनियसली फाइल।
ठीक है सर।
हाँ,
ओके जी सर। और सर, जैसे छोटे केसेज होते हैं हमारे, कोई 5000 का है, कोई 10,000 का है, तो क्या एमएसएमई में अगर वो सेटल नहीं होता है तो आर्बिट्रेटर की फीस उतनी ही देनी पड़ेगी जो नॉर्मल केसेज में जाती है, जो एज पर शेड्यूल आर्बिट्रेशन एक्ट के हिसाब से?
आर्बिट्रेशन देखिए, इसमें भी ना एक थोड़ा सा कंफ्यूजन है, क्योंकि जहां तक कि मैंने बहुत सारे जुरिस्डिक्शंस में केसेस किए हैं। मैंने मध्य प्रदेश में किया है, मुंबई में किया है, जयपुर में किया है, दिल्ली में किया है। तो मैं ये देखा हूँ कि दिल्ली में जनरली लोग मांगते हैं आर्बिट्रेशन शेड्यूल के हिसाब से पैसे, जो कि मांगना भी चाहिए, बिकॉज इट रन्स ऑन आर्बिट्रेशन कंसिलिएशन एक्ट, मतलब कि प्राइमरीली, क्योंकि आर्बिट्रेशन तो वहीं से गवर्न होता है। बट देन मैंने मध्य प्रदेश में ये चीज नहीं देखी है। मध्य प्रदेश में
यहाँ
कोई
पर तो
पैसा
जैसे DIAC बनाई हुई है दिल्ली में, तो दिल्ली में क्या होता है, सीधा वहीं रेफर कर देते हैं ये।
बिल्कुल
तो उसमें
बिल्कुल बिल्कुल,
शेड्यूल के
तो
हिसाब
वहां
से
पे
45,000
आपको
फीस
पैसे
है।
मांगते हैं। बिल्कुल बिल्कुल बिल्कुल, आप
Yes,
सही
sir.
बोल रहे हैं।
तो
DAC
क्या
है, DIAC है, ये दोनों जगह आपको रेफर कर देते हैं, और वहां पे आपको आर्बिट्रेटर का पैसा देना पड़ता है जो शेड्यूल में लिखा है। तो शेड्यूल में जो लिखा है वो 1 लाख रुपए के लिए, नीचे जो लिखा हुआ है वो तो उतना ही है जितना लिखा हुआ है, वो तो फिर आपका उतना पैसा तो देने ही पड़ेंगे आपको। लेकिन वो साथ में जो क्या होता है ना, कि जो आप पैसा दे रहे हैं, मान लीजिए आप 10,000 रुपए का आपका क्लेम ही था, और आपको फीस ही देने पड़ गई 30,000 रुपए
Yes, sir.
आर्बिट्रेटर को।
Yes,
तो
sir.
अब इस केसेस में क्या होगा कि इस केसेस में अगर आप जीत जाएंगे केस, क्लेम अपना 10,000, तो आपको जो 30,000 जो आपने आर्बिट्रेटर का फी दिया वो इंक्लूड करके मिलेगा आपको अपने क्लेम में। तो
Yes.
आपको 30,000 प्लस 10,000 मिलेंगे, 40,000 मिलेंगे। क्लेम जो आपको अवार्ड मिलेगा वो 40,000 का मिलेगा।
जी सर, ठीक है सर। ओके, थैंक यू सर।
कोमल जी,
Am I audible?
Yes, 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 you are.
Acha, I have recently filed one case, but three reports were there, valuation reports. I'm from Moina Ghazi from Calcutta. So two
Okay.
of them were after MSME, my firm was MSME registered. Two of them, and one of them was before registered, but the company was registered. My firm, so my firm was in operation. So what will happen in that case? The two of them will go through, or they will reject the both, all the three, or they will take two, or
So
what
they will
happen?
only entertain the applications which were filed after you obtained the registration under MSME. So any reference case that you have filed before you have
No.
obtained the registration, they would reject it.
Okay. Okay. And sir, another thing, I have got a ISO 9001 certificate. So what does that help in, in getting the funds? Getting the funds.
I do not have this much idea of BIS Standards Act. I'm really sorry to say, because these are all governed under Bureau of Indian Standards Act. So
Okay.
you'll have to refer that act to actually effectively answer the question.
फोन लगा दे।
Thank you, sir. Thank you.
Thank you.
उठा दे टोटल है भाई, कैसे होगा?
We can have the next question.
yes. Komal ji, please ask your question.
हेलो।
Hi Komal, hi.
हाय सर। सर आई जस्ट वांट टू नो कि ये इसका रिकॉर्डेड वीडियो मुझे आपके यूट्यूब पे ही मिल सकता है क्या?
हाँ, if you type Udyamita Helpline in YouTube, you'll see the channel of Udyamita Helpline, and if you click on that channel, you'll find all the videos that were.
Okay, fine. Then today's video will update by today only, right?
In a matter of 2 to 3 days, I guess.
Okay, fine. So I'll check then tomorrow.
Hello.
Yes.
Thank you, sir.
Hello.
Yes, please.
Can I ask my question?
Yes, you can.
Yeah. This is Manish this side.
Okay.
First of all,
Hello.
I'd like to know, Udyamita Helpline is a private entity, or has it got any connection with the MSME?
That Shashank would be able to answer. Shashank ji, if you can please take over this question. It's a private entity.
Okay.
It works in facilitating the MSMEs, hand holding them, making them know of the schemes, loans, and all of those things which are
So
important for them.
you are not partners with the government entity of MSME or endorsed by them?
No, I do not think so.
Okay.
We are a private firm.
Okay. And how to connect with you or Megha?
The contact details are given at the end of the webinar, or you can ask Megha directly in the chat. She'll give you the contact.
Yeah, because there is a contact number 7971718472.
That's Megha's number, I guess.
अच्छा, okay.
Okay, sir.
Supply link.
इसको ही प्रसाद जी, क्वेश्चन मेरे को लगता है इंटरैक्टिविटी भी लेना चाहिए. हेलो.
Yes. Hello.
Hello.
Yes, please go ahead with the question.
Prasad, can I ask my question?
Yes, you can. Please.
See, currently we are facing one of the challenges that we have finished the project with the customer, and in the meanwhile the work order was not able to be, we were not able to take the work order from the client.
Okay.
So
you do not have the work order for the work that you have already done.
Yeah. So what has happened is कि the customer told no, अभी घाई में हम देंगे, but then it got pending only. But we have got almost like 75% payment, and we have made a bill also. The only now the customer is making reason of कि ये rate approved नहीं है, आपका measurement sign नहीं हुआ है. But he is making a delay in the measurement checking. Because this is a project, so we have to.
I got your point. Now he's saying that this rate we did not agree, or this measurement was not approved.
I'm not saying we are not agreed, because I have a proofs in mail, but everything is like not.
So if you have enough proofs, of how was the terms and the conditions were to were to incorporate it, but did not according to some certain extraneous considerations. But then if you want to file a MSCFC reference for your delayed payment, you the work order part जहाँ पे आपको work order लगाना होता है, देना होता है, you can sign an affidavit. एक affidavit आता है जहाँ पे आप swear करते हैं कि no, I do not have a work order, but these were the terms on which the work was given to me, and you sign it on affidavit and you submit it. So it is also entertained by the MSCFC Council.
Okay. But we have also have enough proof, because we have given the partial bills on that same rates. So the rates, you can say because
and
of
you
the
have,
rates,
and you have received the payments too.
Yeah, I have received two payments on that rates only.
Yeah, then through the conduct you can prove that this was the terms, because the conduct shows, right? And all of these will come once your reference is filed and is taken for arbitration by the MSCFC Council. So first of all, you have to do is to file a reference case before MSCFC and to wait for them to start the procedure, right? So
what is the timeline I should be? I mean, what is the exactly?
Where are you based at? Mumbai. So in Mumbai, I have seen 1 year. It takes almost 1 year for them to start with the process.
Okay.
Yeah. But then if you'll see relatively from the other recourses, MSME still is the fastest way to recover.
I agree on that. But the only thing I am worried about is I should not be falling short of proofs and documentations. That is what my challenge is.
No. You will be able to do it easily, because if you have communications in mails, then you can show it to the arbitral council that these were the terms. They have already made payments on these terms, so now they cannot say, they are stopped from saying that these were the terms we did not agree to, right? So because you have a conduct, you have received payment 75% of it, then you have a better chance to prove it through the conduct.
The only customer is now making a reason that this has been escalated beyond the certain budget, so we need to check with the consultant. The consultant was missing in the course of.
So I'll suggest you first issue them a legal cum demand notice, and you wait for them to come and have a conversation with you in this regard. So you
They are
analyze them. Yeah.
They are just making the reason delay tactic, doing a delay tactic like this as this. You have not.
So you write in the notice that within 10 days, if you have not made our payment clear, then we'll file this reference before the MSCFC Council, and then we'll have our dispute to be adjudicated before the MSCFC Council. I mean, most of the cases, I feel that the companies who do not wish to go to disputes unnecessarily end up paying the differential amount, because they also know that they would have to.
For them also.
Yeah,
Because
they would have to. They have to bear the
this.
expense of advocates and everything. If they also go to defend the claim, right? So it is a double-edged sword. So
and this is not only with us. They are done with the other colleague contractors also, like HVAC, like the carpenters.
Yeah. So you can file. You can file the MSFC references after issuing them a legal notice. I would suggest you issue them a legal notice first, because they have made you a 75% payment, and for 25% or for 15%, I do not think their team would seem it मतलब कि उतना उनके लिए ये नहीं होगा, अफोर्डेबल नहीं होगा कि ये 15% पेमेंट के लिए दे गो एंड डिफेंड द डिस्प्यूट बिफोर MSCFC, additionally bearing an expense of advocates and arbitral tribunal and etc.
Right.
So I guess they would try and settle.
If I want to take someone's proper consultation, how should I, whom should I approach?
You can approach Megha. You can ask her what all services do you need, legal services do you need. She would convey it to me. I would let her know my professional charges, and she would convey it to you. If we work out, then I'll be very much happy to help you out, assist you.
So, whom should I contact?
Megha.
Yeah.
You'll find a number somewhere. Megha, can you please send your number to this gentleman?
Is this the number which is written in the Q&A?
Yeah, I guess so. 9717.
Yeah. Got it.
Yeah.
Got it.
That's them. Yes.
Sure. Thank you so much. ये नंबर से ना चलिए
Next question.
Mr. Subhash ji?
Yes.
Mr.
Hello. Please go ahead.
Mr. Subhash ji?
Just a second. Please ask your question. Hello. Yeah.
हाँ सर, मेरा क्वेश्चन ये था कि ओवरड्यू पेमेंट अबो 90 डेज है और कंपनी अभी प्राइवेट लिमिटेड से पब्लिक लिमिटेड होने जा रही है।
ओके।
दिक्कत आ सकती है क्या पेमेंट में?
मतलब कि आपका पेमेंट टर्म पहले 90 डेज का था?
नहीं, 45 डेज है सर, लेकिन अब 90 डेज हो गए, नहीं हुआ है पेमेंट।
ओके। तो आप 45 डेज ही रहने दीजिए। इट डजंट मैटर कि आपका प्राइवेट लिमिटेड है या पब्लिक लिमिटेड है। पेमेंट टर्म्स, इफ यू वांट टू कीप इट 45 डेज, यू कैन कीप इट 45 डेज।
लेकिन कुछ दिक्कत आएगी क्या रिसीव करने में? पेमेंट वो देंगे क्या प्राइवेट लिमिटेड से अगर पब्लिक लिमिटेड होता है तो?
There is a process in company law for doing it, no? It is legally done. So they do not have any ground to refuse payment on this ground that you were a private limited before and you became a public limited at a later stage.
हम नहीं सर, वो कंपनी जो देने वाली है पेमेंट, वो कंपनी प्राइवेट लिमिटेड से पब्लिक लिमिटेड होने जा रही है।
तो then तो they have a bit of more additional compliances to take care of. अगर वो पेमेंट नहीं देते हैं तो उनको कंपनी लॉ के जो फाइलिंग्स होते हैं उसमें बताना पड़ता है कि इनका ये पेमेंट ड्यूज है और ये सब है। तो उनके लिए तो और ज्यादा वो है, मतलब कि कंप्लायंसेस वो हो जाएंगे। तो आपका कोई दिक्कत नहीं है कि बी इट अ पब्लिक कंपनी, बी इट अ प्राइवेट कंपनी, इट डजंट मैटर।
Okay. Thank you, sir. Thank you so much.
Okay. And there are some questions in chat sections as well. I'll check those. How does it affect payment structure? I just answered this. Can a supplier register as an MSME and initiate a claim? Delivering goods to the customer, but failing the case for recovery under MSME. No, they cannot.
Mr.
Yes.
Hanumanji, please ask your question. Subhash ji.
हेलो।
यस प्लीज।
सर मेरा आवाज आ रहा है?
हाँ आ रहा है।
सर मेरे सप्लायर 3 साल से पेमेंट पेंडिंग है, 1.5 लाख का पेमेंट है और उसने सर ने मुझे एक चेक दिया था वो भी मेरा बाउंस हो गया है। मेरे पास एक और चेक है सर जिसमें कुछ भी अभी फिल नहीं किया है और मेरे को अभी वो कुछ भी रिप्लाई नहीं दे रहा है या ना रिस्पॉन्स दे रहा है।
तो आपने नोटिस दिया था उनको चेक बाउंस होने के बाद?
नहीं सर, मैंने नोटिस नहीं दिया था सर।
ये तो देना था आपको, ये लॉ में मैंडेटरी होता है। अगर आपने नोटिस नहीं दिया तो आप सेक्शन 138 में नहीं जा सकते फिर। तो अगर आपका ये एमएसएमई का रजिस्ट्रेशन आपका हो चुका है?
यस हो चुका है सर।
उनसे अग्रीमेंट में या उनसे ट्रांजैक्शन करने से पहले से हो चुका है?
पहले से ही सर, पहले से ही।
हाँ तो यू अब नाउ दैट यू हैव नॉट सेंड द नोटिस, अब आप फिर से उसको बाउंस तो करा नहीं सकते। अगर
सर,
आपका 1 महीने
सर उनका एक और चेक सर मेरे पास है अभी।
अच्छा okay then what you should do is go tomorrow and produce that check to the bank और बैंक को बोलने दीजिए कि अब insufficient फंड ही आएगा मोस्ट ऑब्वियसली। तो वो एक मेमो देती है आपको कि योर चेक वाज बाउंस्ड और उसमें रीजन लिखा होता है कि क्यों, किस रीजन से है। तो इनसफिशिएंट फंड जैसे ही लिखा आएगा तो आपका एक नोटिस होता है, जो कि एक नोटिस जाना होता है ऑपोजिट पार्टी को। आप वो नोटिस देंगे, देन आप वेट करेंगे और फिर 30 डेज 40 डेज का अगर आपका कोई रिप्लाई नहीं आता है तो देन यू विल प्रेफर अ कंप्लेंट बिफोर जेएमएफसी और मेट्रोपॉलिटन मजिस्ट्रेट। तो फिर उनको आना ही पड़ेगा।
ठीक है सर। सर जो नोटिस दिया वो नोटिस बैंक देती है सर, उनको भी हमें लेके जाना पड़ता है उनके पास?
नहीं आप नॉर्मल नोटिस, एक एडवोकेट इशू करता है वो नोटिस। तो वो बस लीगल कम डिमांड नोटिस होता है कि आपका चेक मैंने लगाया था, आपका चेक बाउंस हो गया है इनसफिशिएंट फंड की वजह से, आप मुझको 30 दिन में पैसे दो या फिर मैं कंप्लेंट करूंगा। बस यही होता है उस नोटिस में। वो एक एडवोकेट इशू करता है, वो इशू कर देगा आपका। आप लेके जाएंगे किसी के पास तो, या फिर आप मेघा को दीजिएगा एंड शील गेट इट टू मी टू।
ठीक है सर, चलिए सर मैं आपसे कांटेक्ट करता हूं फिर मेघा मैडम।
श्योर।
हेलो।
यस प्लीज।
हाँ दत्ता बात कर रहा हूँ सर, आवाज आ रहा है मेरा?
हाँ जी आ रही है आपकी आवाज, प्लीज।
हाँ सर, एक्चुअली मैं मुंबई से हूँ सर। कस्टमर है कोलकाता का।
ओके।
हाँ तो अभी मैंने एक समाधान पोर्टल पे आई हैव फाइल्ड दैट एमएसएमई का जो अपना ये है केस, तो उसमें
रेफरेंस
एक्चुअली
केस।
डेट है हम। हेलो।
हाँ या यू हैव फाइल्ड द रेफरेंस केस, उसके बाद?
यस वो फाइल किया, लेकिन उसमें जो समाधान पोर्टल पे जो हमारा इनवॉइस डेट था वो था December 23 का, लेकिन वहां पे एक्सेप्ट नहीं किया। तो वो ये विंडो आ रहा था वहां की डेट शुड बी बिफोर 1 जून 2022। तो हमने जब ये किया तो कॉल कांटेक्ट किया वहां पे जो ऑफिसर है उनको, तो वो डेट बिफोर डेट डाला जो कि बराबर नहीं था। मतलब वो 1 जून 2022 का डाला जो कि गलत है। मतलब गलत ऐसे कि वो सिस्टम ने एक्सेप्ट नहीं किया इसलिए डाला, तो वो इन केस वो कंसिडरेशन होगा ना हमारे केस में?
हाँ, ये आपका कोई रिकॉर्ड है क्या, ये कम्युनिकेशन जो आपने बोला था उनको चेक करने के लिए,
एक्चुअली
MSCFC
इज
MSME जाके?
मुंबई, yes, yes, MSME मतलब she is joint director of this industries only.
Yes, I know her. I've appeared before her also. So
Yes,
what
yes,
you
she
do is,
हम्म
you write a communication,
हम्म
representation sort of thing, कि
हम्म
ऐसा ऐसा तकनीकी दिक्कतें आने की वजह से we were not able to fill in the correct details of our invoice amount, क्योंकि अगर हम लोग
हम्म
करेक्ट डिटेल डाल रहे थे तो it was not allowing us to file a case, ठीक है? और उसके बाद आप देखिए कि आफ्टर consulting the appropriate officers of MSMEs, they directed
हम्म
us to enter the date which is accepted by the portal. So we have only chosen the date which is accepted by the
हम्म
portal. However, it is not the correct date. ऐसे करके आप जाइए और वहां रिसीव करा दीजिए एक बार.
So before accepting, अभी क्योंकि application status is pending only अभी शो कर रहा है, तो
हाँ.
वो शो करने से पहले ही हमें अप्रोच करना पड़ेगा वहां पे, या बाद में किया तो भी चलेगा?
नहीं, आप पहले ही कर दीजिए जाके, क्योंकि अगर बाद में मान लीजिए उसी ग्राउंड पे रिजेक्ट कर दिया तो फिर दिक्कत हो जाएगी.
हाँ, दैट्स व्हाट माय कंसर्न इज। और सेकंड कंसर्न ये था सर कि अभी जो पार्टी कोलकाता का है हमारा, ये तो मुंबई से है, तो आप जैसे बोले कि इनिशियल फेज में यू हैव टू, वो काउंसिलेशन में दो पार्टीज को सामने सामने बुला के रिजॉल्व करने का ट्राई
बिल्कुल.
करते हैं,
यस.
तो हाउ इज पॉसिबल फॉर बोथ पार्टीज टू कम टुगेदर इन दिस सिनेरियो?
He'll have to come to Mumbai.
अच्छा, तो वो
The opposite
कोलकाता का
party will
पार्टी,
have to come to Mumbai. Yeah.
अच्छा अगर वो नहीं,
If he doesn't, then the conciliation fails. Arbitration starts. And if he doesn't
अच्छा
show up in arbitration also, you'll receive an ex parte award. That means कि basis on your pleadings only, the court will grant you an award.
अच्छा अच्छा, तो ये कौन सी स्टेट में ये मैटर नहीं करता है, मतलब इररिस्पेक्टिव ऑफ एनी स्टेट ही हैज टू कम ओवर
नहीं,
हियर?
ये मैटर करता है जहां पे जो MSME, जैसे कि आप MSME हैं, आप मुंबई के हैं, तो ये मैटर करता है सिर्फ आपका जुरिस्डिक्शन. क्लेमेंट जहां पे रहता है, यहाँ पे MSME MSCFC में एक और अच्छी चीज है कि जुरिस्डिक्शन जो है वो हमेशा क्लेमेंट का होता है. तो अगर क्लेमेंट मुंबई का है और उसने मुंबई में फाइल किया है, तो देन दी बायर विल हैव टू कम टू मुंबई. देयर इज नो अदर वे अराउंड.
अच्छा अच्छा, तो और दूसरा एक केस है, सेम स्टेट का एक कस्टमर है, उन्होंने लगभग 20 लाख तक अमाउंट जो है हमारा पेमेंट इज, अभी उनका इंटेंशन लग रहा है कि नहीं देना है, तो अभी उन्होंने एक रिक्वेस्ट डाला कि फर्दर 5 मंथ्स के लिए यू वेट, तो वो 5 महीने में हम कर देंगे, बट इट सिम्स कि वो करने का मन नहीं है उसका, क्योंकि वो कुछ मेल को रिप्लाई नहीं कर रहा है, इज नॉट रिप्लाइंग एनी कम्युनिकेशन, खाली बोल रहा है कि टाइम दे दो, हम कर देंगे पेमेंट। तो ये केस में हम उनका ये कर सकते हैं फाइल, या वेट करें, क्या
बिल्कुल
करें?
कर सकते हैं. मैं आपको सजेस्ट करूंगा कि इस केस में यू सेंड देम अ लीगल नोटिस फर्स्ट, क्योंकि अगर वो लोग पहले से बोल रहे हैं कि वो लोग देंगे वेट करने के लिए, तो आप लीगल नोटिस देते हैं, तो इससे जो थोड़ा सा है वो होता है ना, पैनिक और फ्रैंटिक सिचुएशन आता है कि अरे यार
अच्छा
लीगल नोटिस आ गया, अगर हम नहीं देंगे तो हो सकता है केस फाइल हो जाए. तो अब उनको केस लड़ना होगा, ये सब करना होगा, उसमें उनके पैसे लगेंगे, तो उसमें जनरली लोग डिसाइड करते हैं, जनरली अगर जिनको पैसा देना होता है, जिनके मन में चोर नहीं होता, वो लोग जनरली डिसाइड करते हैं कि चलो सेटल ही कर लेते हैं, पैसा देके खत्म करते हैं. तो वो
अच्छा
आपका लीगल नोटिस से ही हो जाएगा. आपको जनरली जाके केस फाइल नहीं करना पड़ेगा, फिर केस आएगा उसको विड्रॉ करना पड़ेगा, ये सब नहीं करना पड़ेगा. इसीलिए मैं बोलता हूँ बार बार कि इफ यू हैव एनी वो अपने दिमाग में कि द अपोजिट पार्टी कैन आफ्टर द रिसीट ऑफ अ नोटिस पे मी द डिस्प्यूटेड अमाउंट, देन यू शुड ऑलवेज इशू अ नोटिस फर्स्ट.
ओके, तो वो एडवोकेट से ही चाहिए, हम ऐसा मतलब कंपनी?
जनरली जो होता है एडवोकेट के नाम से जाता है, तो इट क्रिएट्स द पैनिक सिचुएशन एंड फ्रैंटिक सिचुएशन, बिकॉज अदरवाइज यू आर तो राइटिंग ओनली एंड ही इज नॉट replying. But I have seen a lot of cases, in almost 70% cases, whenever an advocate sends a notice, good corporate houses do reply back.
ओके, एंड ये नोटिस कैसे भेजा जाता है, बाय ईमेल थ्रू या बाय पोस्ट, या कैसे भेज?
ईमेल भी भेज सकते हैं, बाय पोस्ट भी भेज सकते हैं, दोनों से भेज सकते हैं, कोई दिक्कत नहीं.
अच्छा अच्छा, ठीक है। और हमें अगर आपने ये मुंबई, यू ऑलरेडी टोल्ड ने कि मुंबई साइड, और ये आपने ऑलरेडी हैंडल किया है सब, तो हम
Yes.
हमारा केस अगर आपको ये कर सकते हैं हैंड ओवर, अगर हमें लगे कि
श्योर आपके लिए आपको पहले ना पूरा डॉक्यूमेंट्स देना पड़ेगा मुझको. आई विल सी व्हाट द केस इज एक्चुअली, एंड देन आई विल लेट यू नो माय प्रोफेशनल चार्जेस. इफ यू आर ओके विद दैट, देन वी विल श्योरली मूव अहेड. नो प्रॉब्लम.
बट टेंटेटिव सपोज अभी कितना दिन लग सकता है? टेंटेटिव आई एम आस्किंग बिकॉज आई नो द प्रोसेस इज लेंथी वन, बट कितना दिन लग सकता है ऐसे?
Once we file a MSCFC reference, no, it can take anywhere between 6 months to 1 year for just to get them started with the conciliation proceedings. Now, I know no advocate would be dead honest to you in this regard, because अगर मैं आपको यही पहले ही बता दूं कि 1 साल लगेगा तो कोई आता नहीं है जनरली. बट देन मैं आपको झूठ बोल के क्या करूंगा? जो लग रहा है वो लग रहा है. वो है अब हमारा एक दिक्कत लीगल प्रोसीजर्स में कि थोड़ा लेट चलता है, तो अब वो है, अब कुछ नहीं किया जा सकता है इसमें, क्योंकि अब वर्कफोर्स ही नहीं है. हाँ, कहाँ से लाएंगे वो इतने ऑफिसर्स?
हेलो सर, आप कौन से लोकेशन बिलोंग करते हैं?
I am originally from Patna, Bihar, but I've always practiced. I've learned everything in Delhi. Now I've gone independent, so I do cases of both Delhi and Patna. Both are not that far from each other. It's only overnight journey, so I easily manage both the jurisdictions now.
Right?
Sorry,
your office is in Delhi, Delhi or Bihar?
Yeah, both the places.
Okay. तो आपको एक रिक्वेस्ट रहेगा मेरा, आपका या मेघा जी है, शी इज योर कौन is what she is looking after?
She works with UDYAMITA Helpline. I am an expert which is impaneled with UDYAMITA Helpline. They call me now and then for knowledge dissemination programs, for speaking webinars, for assisting their clients. So I am just an expert who is associated with them. I am not a part of UDYAMITA Helpline, so to speak. These guys are Shashank hai, Megha hai. ये लोग UDYAMITA Helpline.
Yes, I got. बट मुझे आप दोनों का नंबर अगर मिल जाए तो अच्छा रहेगा. कैसे मिल सकता है?
Megha would do the needful.
Okay, both the numbers, your number as well?
Yeah, sure. No problem.
Okay, हाँ, वो एक बार शेयर करिएगा. मैं I'll contact you afterwards, sir.
Sure.
Thank you for your valuable information, sir. मैं पूरा ये अटेंड कर पाया, बीच में थोड़ा कॉल आता था, लेकिन बहुत ही इम्पोर्टेंट और थोड़ा ये लग रहा है कि we can extract money from our customer. So hope for the best.
I'll do my best in doing so.
Thank you so much, sir. Thank you so much.
Thank you so much.
Yeah.
Any more questions?
Let me check, sir.
Yes, please.
Mr. Amit ji.
मैं कुमार प्रतीक हूँ. अब बताइए प्लीज क्वेश्चन.
मिस्टर अमित जी, आप अपना क्वेश्चन सर से पूछ सकते हैं. ओके. सुभाष चंद्र जी. ओके, आई थिंक सर क्वेश्चन सारे कुछ क्लियर हो गए हैं. मिस्टर अमित जी. या प्लीज.
मेरा भी क्वेश्चन, मेरा आंसर मिल गया भाई. मेरे को बस वही प्राइवेट आप लोग से कुछ असिस्टेंस लेना था सर, पेमेंट के रिगार्डिंग.
Yes, please get in touch with Megha. She'll do the needful. She'll connect you with me. What terms can we add in our PO? So someone has asked this question. This is a very good question, so to speak. तो आप इसमें, जैसे कि मैंने बताया था कि आप पीओ में क्या क्या टर्म्स ऐड कर सकते हैं. अगर आपको एडवाइस करूं तो मैं तो आपको बोलूंगा कि एक अग्रीमेंट बना लीजिए आप, मास्टर अग्रीमेंट, और जिसको अपना उसमें रेफर किया करिए वर्क ऑर्डर में, कि ये है, ये वाले रेफरेंस से, ये वाले उससे गवर्न होता है मेरा जो वर्क ऑर्डर है, और वो भी साथ में भेजा करिए पार्टी को. अगर आपको वो नहीं करना है तो देयर आर होस्ट ऑफ अदर कंडीशंस, जो टर्म्स एंड कंडीशंस जो आपने पीओ में डाल सकते हैं. आप उसमें डाल सकते हैं कि अगर कोई डिलेड पेमेंट है तो उस पर इंटरेस्ट कितना लगेगा. आप उसमें ये डाल सकते हैं कि 20%, 24%, जो भी आपको लगता है जेन्युइन है, वो आप डाल सकते हैं. कितना इंटरेस्ट पेएबल होगा पेमेंट ड्यू हो जाने के बाद. फिर पेमेंट टर्म्स कितने में ड्यू होंगी, पेमेंट कितने दिन के बाद करना है. फिर आपको ये लिखना है कि 15 दिन या 20 दिन आफ्टर द डिलीवरी ऑफ मटेरियल्स, इफ नो inconsistency or deficiency has been pointed out by the buyer, then it would mean that it is deemed accepted, unequivocally accepted by the buyer. So all of these terms are there. आप इसमें और भी कुछ ऐड कर सकते हैं, वो डिपेंड करता है आपके बिजनेस टू बिजनेस पे. सो गेट इन टच विथ मेघा, और मैं आपके बिजनेस के रिक्वायरमेंट्स के हिसाब से इसमें और क्या क्या ऐड कर सकते हैं मैं आपको बता दूंगा.
तो बता देते हैं. ठीक है.
Are there any more questions?
Hello.
Yes, please. Please ask your question, sir.
इससे बात करो ना फोन पे पहले.
सर आई थिंक सारे क्वेश्चंस हो गए हैं. कुछ मतलब सर Q&A के अंदर भी हैं, एक बार आप उसको प्लीज चेक कर लीजिए.
यस मैं वही चेक कर रहा हूँ बस लास्ट. So Dipali has asked what terms we can add in PO. So I've already stated कि आप क्या क्या टर्म ऐड कर सकते हैं PO में, और अपने बिजनेस के हिसाब से और जो पॉइंट्स हैं वो कस्टमाइज होते हैं. तो let me know about your business, or connect to Megha. She'll make you connect with me, and then I'll, according to your business, advise you what all terms that you can use. And जैसे एनी फॉर्मेट ऑफ पीओ और टर्म शीट भी पूछा गया है नवरत्न अग्रवाल द्वारा. तो ये टर्म शीट जो है सर वो अग्रीमेंट्स होते हैं. अगर आपको अग्रीमेंट्स बनवाने हैं तो ये अग्रीमेंट आपके बिजनेस के हिसाब से बनता है, एंड इट इज ओनली वंस दैट यू हैव टू बेयर द एक्सपेंसेस ऑफ अग्रीमेंट, राइट? क्योंकि आपका बिजनेस जो है वो आप बिजनेस कर रहे हैं वो अग्रीमेंट के बेसिस पे ही आप करेंगे, तो आपको बस एक बार बनवाना होता है. समझ रहे हैं आप? तो ये आपको, अगर आपको चाहिए एक अग्रीमेंट है वो मेरे पास, तो प्लीज कनेक्ट विथ मेघा and she'll connect you with me, and I'll, according to your business needs and specifications, will draw out an agreement for you. I guess I've answered all the questions, Shashank ji.
Okay, तो डन सर, हम लोग इसको यहीं पर.
Okay. Should I end the webinar now, sir?
Right, sir.
Okay. Thank you so much. Thank you so much for everyone for joining in. I wish you all the very happy new year and everything. Please take care of all these things which I have spoken in the webinar today, and I wish ki you have a very good business year. Upcoming good business year you have. That's all. Thank you so much, everyone. Thank you.